This is the clerk.
Yes.
You are now at capacity for September 12th.
All right. Well, Mr. Zandy just took the last day of the 12th, so blame him when we can't set anything to that date moving forward. All right.
I'll keep it in mind. Thank you.
All right.
Your Honor, not a strike or set over, but the Anderson v. Erickson matter should be very, very quick. It's just a presentation of the contempt order. We just have a couple of questions on the language. Mr. Roberts and I just saw him here. I think it'll be very quick. We've already given you an update via email on the reunification.
And then I did see an email. Let me see. Regarding the progress with the reunification assessment and working with Ms. Rosen.
Yeah, my only concern was that she missed today's. It appears she has rescheduled for Friday. As long as that goes through, I don't have an issue. It would only be if that is also canceled due to a health issue.
Okay, and I did see the urgent care snapshot that was attached to that. Mr. Roberts, anything as far as that goes?
No, I think we're fine on that, and fingers crossed that there's no more hiccups, but that's fine. We can just move to the form of the order.
All right, where are the concerns that either party have?
Yeah,
So
I'll
go
let
ahead,
him
Ms. Winkles,
speak.
I'm sorry.
I'll just say, Mr. Roberts can have the floor because I've submitted what I believe the order was. Although we are in agreement, you did say 5 to 15 minutes, and I put 15 minutes in. I have no problem that being changed to 5 to 15, and I'll let Mr. Roberts talk about his objection.
Okay.
So the reasons for contempt in section 4, my reading of my notes and the court's ruling was that the court did not make a contempt finding on decision making. The court did make a contempt finding with respect for making the child available for unification within 14 days. And the court did not make a contempt finding for the video visits because there was some confusion there, and the court ordered the video visits but didn't make contempt findings. So for those numbers 1, 2, and 3, I think number 2 is the only thing the court made an order for. And if the court does make an order, does keep that in, I think the language on line 2 and did not do so for over 2 months is inappropriate because the court order was on June 6th. 14 days from that would be June 20th. And then as of August 15th, less than 2 months later, my client had her first meeting. And
I used essentially exactly what the court said. The oral order was from May. The signed order wasn't until June because it was bounced around a lot to get back in front of your order, but an oral order is still an order of the court. Your Honor actually said 2.5 months, but I put 2 months in there. I'm fine with whatever Your Honor does state. However, Your Honor made it very clear that she did not involve the father in any decision making. I think that one was clear. The video visitation was a little bit less clear. So on that, I'll defer to Your Honor, but you were very, very clear that there was no attempt by Ms. Erickson to involve dad in decision making, even though that's what the order stated.
In looking at my notes and the clerk's minutes, I think I am. My recollection is there was a finding to the decision making and reunification. I agree that there was no finding as to the telephonic or video visitation. So I'm going to strike 3 and leave 1 and 2.
In the form of 2, is the court going to strike the last part of the sentence, or are you going to keep that in?
I'm going to leave that.
Okay. And I wasn't there. I was retained for the May hearing, so I'm obviously just defer to you. With respect to, next issue would be reunification was to start within 14 days, not immediately. 4A line 2 says it must begin immediately. 14 days was in the order, so I'd ask that language be modified.
I have no problem with that.
Okay. I'll strike immediately and replace that within 14 days.
Okay.
All right.
Section 12, court review. The first sentence I have no issue with. The second sentence is not about review. It's about the court's mindset or concern. I think that is inappropriate for this section. I've asked the second sentence be stricken, excuse me.
And I just wrote down exactly what Your Honor stated. So whatever Your Honor wants to do is fine with me.
All right. I appreciate that. I will strike that second sentence.
And then section 13, Number one is outside of the scope of the contempt order that was brought. That is in a prior order. It was brought as a contempt issue. The court did not find number one as contempt. So I think that's outside the scope of this order entirely. Number two, I agree. Number three, I think we've already modified and agreed. Number four, I agree. So just number one is my issue.
All right, I'm going to make the change on number three that for 5 to 15 minutes. Any response on the number one?
The number one is just, again, what Your Honor stated. I try to keep these orders as close to what Your Honor states as possible. So if Your Honor seeing that now wants to change it or feels comfortable with it, I'll defer to Your Honor.
And I know that this is in a different order, correct, Mr. Roberts?
Yeah, it was, they brought it up for contempt because she hadn't done the drug or alcohol evaluation. The court found that the time is not ripe for this to be brought. So it's basically regurgitating a prior order. So it's a true thing, but it's not something related to the contempt other than no contempt being found for that issue.
And my concern here is that it still hasn't been collateralized, and there's no ROI. And so I feel that I will just have to come back on another contempt once I let that 6 months pass, which seems just to be delaying this. And so that's why Your Honor stated it needs to be collateralized. Dad has the time to do this now. Mom needs to sign an ROI needs to be filed with the court, which is why
we did submit. I'm sorry to interrupt. We did submit ROIs in response. Those are in the court file as of the contempt hearing last time. So that's not an issue, and the court has that information. I realize it is mostly a form issue. I don't think we're arguing about the substance, but that's my position on the narrow issue.
It does indicate other orders. Clearly, the other things are associated with the contempt that we dealt with. Excuse me. I'm going to leave it in there just to reiterate that that is something that's been ordered and that needs to be followed through on.
Sure.
Anything else on this order?
No, Your Honor.
It's ready for.
And was Your Honor able to review that assessment I sent over this morning?
Yes.
Okay.
And let me see, did I get an order on this?
I believe we sent that over ex parte, Ms. Rush. Do you recall?
That was my thinking as well. It was pretty soon thereafter because it was just an interim order that Your Honor had kind of ordered pending the DV evaluation. So I thought we had done one pretty quickly, but I can double check.
No,
I do see it at least in my file on the 26th.
It was entered ex parte and signed off by Judge Basher.
Okay.
There we go.
So, and I made a note of that, but I didn't read it before I asked the question. So that part is taken care of. And then it's a review hearing on the DV evaluation. And let me just go back to that email. Any comments? And Ms. Rush, you received this email and were able to review it as well?
I did, Your Honor. I mean, I've been able to review it. That's been about the crux of it. So I've not been able to review it in great detail with my client, but I'm ready to proceed today.
All right. Whomever wants to start.
Okay, well, it's our motion. So what I'll do, I mean, I'll just summarize kind of, the facts of the case haven't changed, but for this DV report that came out. So just kind of reiterating what my client's asking for. So the parties have a son, Grayson, who's actually going to be 4 in a couple days, on the 31st. My client, her position was that she'd always been his primary parent. Back last September, the court basically made a decision based on some information that was brought to the court that Grayson would go live with dad primarily and have supervised visits with mom. That was entered into temporary parenting plan last November. My client has since then had supervised visits 2 times per week for 3 to 5 hours per week. That recently, with the interim order in July, transitioned to unsupervised visits. And I don't have the order in front of me for the exact language, but she has substantial time during the weekday and on the weekends. My client was ordered to undergo a psychological evaluation with Dr. Deming. The parties did undergo a GAL investigation with Ms. Turnbull, who I think is present today. And basically after that initial hearing, the parties were waiting for these evaluations to be completed. Those were issued not long ago. First, the psych evaluation was issued that was given to the GAL so she could complete her investigation. And the GAL report, basically came out, and our belief is that it's corroborating what mom's been saying the entire time. Basically that dad has made allegations, but hasn't really had no proof or corroboration, and that mom has proven herself to be basically telling the truth, getting the help that she needed, that she needs, and perfectly capable. And I'm going to read, this is from page 19 of the GAL's report. There is zero evidence to indicate Ms. Sweet cannot continue to be Grayson's primary caregiver, as she has done throughout his entire life. So I think that's a telling statement. Another telling statement from that same page, again, page 19, this investigator is seriously concerned that Mr. Emter has knowingly made false accusations against Ms. Sweet, keeping Grayson away from his mother to improve the likelihood that he will receive 50-50 custody. So there's other concerning statements throughout the report. Both Dr. Deming and Ms. Turnbull made a comment that this was a domestic violence relationship, and that regardless of what anybody says about it now, their belief was that mother was the victim of domestic violence by father, multiple forms of that. We're not saying that he was physically abusive with her all the time, but there was multiple forms of abuse going on. Like I said, the GAL indicated in her report that mom was getting help for that kind of being in that kind of relationship. My client continues to do that and has no trouble continuing on with that path. At the last hearing, Your Honor did drastically increase my client's visitation and ordered that Mr. go get the DV with collateral information, and he has since done that. I will note from my read of the DV report, they indicate that he's doing a good job in sobriety. Both of these parties have been clean for a number of years. Both of these clients have not had criminal issues in a number of years. So both parties are to be acknowledged for that. What the DV kind of report was interesting. Sorry, real quick here, find it. Well, it went on to say that, there's no current issues, that dad has some risk factors based on a history. He doesn't have any mental health diagnoses. He's in recovery. I mean, there are a lot of good factors, but then in the assessment summary, it does talk about that there have been behaviors reported that would constitute domestic violence, and that there have been some behaviors reported even though he's clean and has been controlling his behavior even more. So the expert that he chose to go to for his DV eval suggested mental health trauma evaluation by somebody who has experienced in a specific area of childhood trauma, and that he comply with any recommended treatment, and 12 initial sessions of anger aggression management with an emphasis on emotional regulation and effective conflict resolution. So we do believe, again, that this DV evaluation further corroborates what my client's been saying, what the GAL said, and kind of what the psychological evaluator said, kind of offhand, which was then incorporated into the GAL report. So we are asking that, the GAL made very clear recommendations that mom has been historically primary. Mom is more bonded with Grayson. It's not to dismiss dad as a parent, but mom is the one who has the stronger relationship and is more likely to support Grayson's relationship with his other family members. The GAL did recommend that mom be named primary and dad get up to 24 hours every other weekend, plus 4 hours twice mid-weekly. I realize that counsel is going to argue that that's a drastic change. It is, and my client believes it's a drastic change to kind of right what's happened over the last year. My client's not opposed if he were to get some extra time, on top of what the GAL recommended, but we are asking that the court adopt those recommendations, move forward with transitioning her back to having Grayson full-time. And I understand the court will probably also adopt the recommendations of the DV evaluator. I believe they were able to talk to my client, read the GAL report, read the pleadings, and talk to whoever else they wanted to talk to, so it was fully collateralized. So I would just indicate again, the concerns that we have is that dad continued to lie, and as you saw in the GAL report, nobody except for his sister had even any sort of corroboration to these things that he was talking about. He was trying to say my client was still using drugs, was misusing Suboxone, all of these kind of drastic things that grab the court's attention when we're at temporary orders, and the court obviously has to do what they think is necessary to protect the child. But he was throwing out all these kind of red herrings. And my client has gone through the ringer to make sure that Your Honor knows that they weren't happening with her at the time. They're not happening presently, and she's taking care of herself that she needs to take care of for the past. So we are asking that the parenting plan be entered per the recommendations, and that anything else that flows therefrom would come from that. And I'm happy to answer any questions that Your Honor might have.
Thank you. Ms. Bliss?
And Your Honor, as course where I do represent David Emter, Your Honor's likely recalls all of the argument and discussion that occurred in July. Much of counsel's argument today is repetitive of that last hearing. Even with all of that in consideration, at the end of that hearing, Your Honor essentially said, and to the recommendation of mother being primary residential parent, just because that was the history prior to this action. Your Honor indicated that there wasn't substantial change or a reason as to why a drastic change of reducing my client from, at the time, nearly 100% physical custody of this child, with the exception of supervised visitation of mother, to 24 hours every other week. There was nothing to substantiate those changes. What counsel relies on is statements in the GAL report that father lied, that he misrepresented evidence. But what he relies on and what he asks the court to consider in his previous declarations, what he provided to the court was cold, hard facts. There were video evidence, photographic evidence, statements alike. It's not simply a he said, she said. There were physical documentation and evidence to support his concerns. And the court, this court in particular, Your Honor, made the initial ruling, shared those concerns. This DV evaluation brings back exactly what my client has ascertained from the beginning, that he does not have domestic violence issues. If Your Honor did read the evaluation, it largely encompasses childhood trauma, reacting to triggers or reacting to instigations, arguably by Ms. Sweet. The DV evaluator specifically says there's likely not been any concerns over the last 5 years since both of these parties have been in recovery. So to indicate that all of Ms. Sweet's allegations were accurate and Mr. Emter lied and so on and so forth, which is the argument before the court, is simply not substantiated or bore out by the evidence. My client did receive this assessment, has taken the steps to begin a mental health evaluation. Granted, we did just receive this evaluation late Friday evening. He just received it yesterday. So we're very early in that process, but he is on board with undergoing that mental health evaluation to address his childhood trauma. And he has also agreed to begin that anger management or aggression management with an emphasis on emotional regulation and effective conflict resolution as recommended by the provider. I believe he's held up everything that the courts required or asked of him to do and gone above and beyond and done so before the courts even ordered it. Looking to what is in Grayson's best interest, the court is aware that simply getting a guardian ad litem report is not adequate cause to change parenting plan. Everything that's been provided by my client in the prior hearing indicates that Grayson is thriving in his care. He's set to start school next week, so making this drastic of a change this late in the game or without a full hearing in this matter, I think is inappropriate. Your Honor had your own position at the last hearing and ordered mother to have, I believe, every other weekend from Friday to Monday. My client indicates those visits have been going well, and he would propose maintaining that schedule as we go through the school year and as this matter sets forward to trial. My client doesn't have any objection to mother maintaining that schedule. It's my understanding she also has 3 to 5 hours twice per week, I believe. Obviously, with school starting, that'll have to be geared around schooling, but my client doesn't have any objection to that. At this point, maintaining Grayson's status quo is in his best interest. There's been nothing provided that indicates that he's not thriving in my client's care, that returning to mother's care is in his best interest. So at this point, we're asking the court to maintain status quo.
Thank you. Ms. Turnbull, do you have, I'm assuming you saw the DV evaluation as well?
I did.
Any comments or concerns from your perspective?
No, I stand by my report. I do think that Grayson probably needs more time with dad than I originally recommended, and I do support father following through with the treatment recommendations. I think that those are appropriate, and I think that I would be supportive of Grayson having more time with dad when he follows through and as he follows through with those.
All right, thank you. Where are the parties located? Are they both in Longview, Kelso area, or?
I believe so. My client's on the line. Roxanne, can you just remind me what city you're living in right now?
We're both in Longview.
That's what I thought. Okay, good. Thank you.
All right, thank you. Ms. Rush, any response?
No, other than I would just indicate to the court, the videos and the photos and all these things that they brought up initially, they keep saying that we have cold hard facts. Those have been borne out by the GAL specifically, who said it was poor judgment, but that's not indicative or dispositive of who's been primary. So, my client's position would be that, Grayson needs to be returned to her with, the routine primary parent, et cetera. The longer he's with dad, the easier it is to say, well, now he's been with dad for 9 months, and then we're going to have 10 months, and then we're going to have 11 months. And from our perspective, it just feels like we're further rewarding him for not potentially bringing the best information to the table at the outset that has now been sussed out, and most of it has been opined to be false. And so the longer he's with Grayson, they get to say, well, he's been primary parent for the last 11 months. And so that's just a concern from a legal perspective as far as people kind of harping on that argument. But we like I said, we are requesting something like the schedule. Like I said earlier, we're not opposed to him having a little bit more time in the schedule. gives. And I believe Ms. Turnbull just was appropriate, said that would be appropriate as well. So.
I guess, given everything that I've seen, and I would agree at the beginning of this case, there were a lot of, strong concerns the court had based on some of the behaviors and accusations, whether they all were borne out by the information that was provided is sort of beside the point. There were a lot of concerns at the beginning of this case. What we have seen is maybe the concerns with mom aren't as significant as initially thought, but we also have seen that dad has been able to step up to the plate and has been able to be a full-time care provider for the child for a significant period of time. How do I say this? I don't like the idea that just because you've always been the primary care provider, that doesn't, that cuts out time for other parents. And I like to try to approach these things as, how are we getting to a 50-50 plan? And that's sort of where I'm at right here. Dad has been primary because of those concerns that were raised. Those concerns have been addressed. Those concerns have been either addressed directly or maybe not as huge of a concern as initially thought. The last proposed parenting plan I have from Ms. Rush is essentially pretty close to what we're doing, but opposite. So mom would be primary, dad would get every other weekend, as well as I think 4 hours twice a week during the week, as long as his shift work allows that to happen. Otherwise, that would be rescheduled.
And Your Honor, just to remind you of one factor, and this is in Ms. Turnbull's report, dad does work a lot and he has an interesting schedule. So I would just remind the court of that I don't know if she recommended a straight right of first refusal, but she definitely made it clear that if dad's working, Grayson should, he shouldn't have Grayson when he's working all the time.
Ms. Bliss, is this a schedule that we know well in advance? Is this, I know we live in a community where we have a lot of shift workers that are on set schedules. Some of them, their schedules change very regularly. Where does Mr. Emter, do we have any kind of foresight into what his calendar looks like?
My understanding of what his schedule is that it was fairly consistent. I know he had just changed it right before that last hearing, so I was reflecting back on his declaration. He indicates that he's no longer working graveyards. He works a 2-week rotating day and swing shift. Latest he's home is 10 p.m. So that's the information I have currently.
Yeah, and I would just indicate that that's similar to what the GAL reported, which was father works a shift schedule that rotates between days, swing, and graveyard. Mother works as a hairdresser 25 to 35 hours a week during the day only. So that's what she commented on both parents' employment schedules.
And then Ms. Bliss, does, I don't want to go too far into the weeds here, but does, how many on the 2-week rotating, how many days does he have between his day shift and his swing, or is?
I don't have any knowledge of that.
Okay.
Oh, and really quick, Judge, it actually does look like on page 19 of the GAL's recommendations, if Mr. Emter's work schedule does not allow him to be off work for visitation, that he not be disfavored, but that Grayson stay in Ms. Sweet's custody. So I think that's what we were looking at.
All right. Well, given all the information, here's where I'm at. I'm looking at as close to a 50-50 as we can get it. That's where I'd like to be. However, I don't want to forfeit a third or half of father's time because I don't know what his work schedule is. So that's where I rely on the two of you to see if we can look at and we can get from Mr. Emter a calendar through the rest of the year, and maybe something that he can continue to try to work with his employer to have. And I do think, based on mom's job, dad's at work, she should be the care provider if he's not at school. But I think we need to work towards a 50-50 plan, and that's something that I don't know that I can do on the docket with the information that I have. The 12th is full. I don't know if the parties would be inclined to maybe set this for a presentation docket on a Friday at 8:45 and provide a little bit of more supplemental information, and we can kind of work through crafting a plan over 15 to 30 minutes on a presentation docket.
That would be fine with me. I just have to check because we have dockets on Fridays too down here. So I just want to compare.
So I would say, given Your Honor's ruling, Ms. Rush, why don't we try and figure something out? And then if we can't, then one of us can just note it up on that Friday docket in the next couple weeks. You can look at your schedule. Does that sound appealing?
That sounds fine. Yeah. I mean, if we can just learn what his, like, if we know, hey, he's working days, this is the hours. If he's working swing, these are the hours. That'd probably be helpful. Judge, are you looking for something when you're saying as close to 50-50 as possible? Are you looking for something where they would be like splitting up the week and then rotating weekends? Or are you looking more like week on week? I mean, what kind of do you envision this looking like?
We have I'm backing up here. Sorry.
He'll be 5 this month.
He'll be 5. So he's starting school.
I think, isn't he going to be 4 this month?
He'll
Sorry.
be 4.
Yeah, he'll be 4.
Okay.
My mistake.
So I guess I'm not as concerned about that at this point in time, but obviously we want to craft something that will go into school years. If the parties are both local and can agree on a school district or school that he'll start in, then I guess I'm not as concerned about it being a midweek exchange. If the parties feel a week on, week off would be easier with mom having potential childcare during dad's week when he's working later nights. I'm fine with that. If they can agree on that, that in my opinion would be the best. If they can't, then I'm happy to draw the hard lines.
All right.
Very good. Thank you, Judge.
All right. Thank you.
We
Good
got
luck.
number 2,
Thank you.
which is a notice of intent to relocate. Number 2, Quiros and Calvert.
And I have number 15. I think it could be very quick.
So far, what they've said has been quick, has not been quick.
I know that's other attorneys. I don't do that.
That's other attorneys. 8.
And the reason I think it's going to be quick, Your Honor, is I haven't received a response of any type.
I have not received a response of any type either.
And I don't see, I served counsel, he had counsel, and I served Mr. Blowers personally because I wasn't sure, given the notice of appearance of counsel was like a limited notice of appearance. So I served them both and we've gotten no response. And I've submitted a proposed temporary order to Your Honor that I'd like to get entered if we can. And then I have a question. We need Mr. Blowers to move out of the house and my client be allowed to move in immediately. This house is in foreclosure. And I'd like to have a review set to make sure that happens. If we could, set this over for next week to see if he's complied with your order that he move out within 48 hours.
I have 2 of those. Are they different?
There should be a temporary restraining order and a temporary order. You should have both of those. I filed them separately because they're separate documents. There's a proposed temporary family law order and a proposed temporary protection order. She's a restraining order.
Okay. It looks like I got 2 copies of each. So that's why I was a little, but they appear to be identical. Let me just make sure that I don't see any differences here. Okay. I must have just gotten 2 of each, and looks like they're both signed August 8th. Is that the most recent, August 8th for both?
Yes, I signed them on August 8th when we filed them.
Okay. All right. I don't know, for whatever reason, there's 2. So, but they appear to be identical.
Okay.
So I've reviewed everything that's been filed, and given the lack of response, I did indicate, as you already stated, that there was an agreement of service via email with prior counsel, and I did see that you served prior counsel and the individual listed, the respondent.
Right.
Where does it, can you help me see where, and maybe it's in the temporary order.
It's in the temporary order on the bottom.
The 48 hours. There it is. Okay.
Yeah, bottom of page 2.
All right. All right. I have reviewed both orders and signed off on those orders. And do you want to review well, the 12th is full. I haven't heard that the 5th, is it the 5th next week? I haven't heard that the 5th is full, or we can go to no, we can't go to the 19th. We go to the 26th. So we can go to the 5th or the 26th.
The 5th is preferred, Your Honor.
All right, we'll review this next week, September 5th at 1:00 p.m.
Perfect.
Thank you.
Thank you, Your Honor. See, Ellie, I told you.
We had supplied you weren't. a bench copy, because we had been served with new information that we had not been able to address. Did the court get a copy of my client's declaration?
Was it the declaration that was filed yesterday?
Yes. We sent a bench copy back also.
Yes, hold on. And it's just a couple pages.
Yes, it's just 2 pages. Okay, thank you.
I have a question just straight out of the gate. I know, Mr. Baldwin, this is your motion. It appears to me, based on what I've reviewed, that these folks have been operating essentially under a 50-50 plan for at least a few years.
That's correct, Your Honor.
For, I think, 5 years,
5 years?
at least. I'm sorry, 8 years.
I think 2015, Your Honor, was the
There was a
current
2015.
plan.
Okay.
Right, and there was about a 3-month break-in period, but then since that point, there has been a 50-50 plan.
Okay. I just wanted to ensure that obviously that's a concern here, but Mr. Baldwin, go
Yes,
ahead.
Your Honor. And it is accurate, Your Honor, because this is a 50-50 plan, or a plan where both parents have substantial time with the child. There's no presumption in favor of a move. But the court looks at the same list of non-exhaustive factors in 2609-520 to determine whether a move is in the best interest of the child. I think our declarations in support, as well as inferences the court can draw from the declarations of the objecting parent, establish that at this point in time it would be in the best interest of the child to allow the move on a temporary basis for a JL to be appointed in the manner to proceed in that manner. First and foremost, this is a situation where, with the impending need for relocation, there is a likelihood that both parents would have some impact on their residential time, whether the move is allowed with the child or not. In looking at the basis for allowing or authorizing a move, court looks at a number of factors. Several of them, I think, here are the most significant. One is the relative strength, nature, quality, extent of involvement, and stability of the child's relationship with each parent, siblings, and other significant persons in the child's life. This is a blended family situation where both parents have since begun new relationships or are remarried. Mr. Calvert is remarried and has another child. My client is in a long-term relationship, her fiance, and she have one child and she's pregnant with another. So there are half siblings and additional relationships that this child has that will be affected by a move under either circumstance. He is closely bonded to both of his siblings. However, our position and position of declarations is he's more bonded to his sibling with my client, but also I think significantly bonded to his grandmother. There's no indication to the contrary, although Mr. Does indicate that he's more bonded to dad. I don't think that's really what the consideration here is. He's bonded to both parents, but the court is looking at the strength, nature, quality, extent of involvement, and stability with the parent, siblings, and other significant persons. Here, grandma is a significant person in this child's life. There's a longstanding relationship from the child's birth until the time that Miss Cox moved to Arkansas to try and grow this farm and get additional acreage, that he was closely bonded with his grandmother. Mr. Calvert, in his responsive declaration from yesterday, talks about how when his parents were in ill health and were dying and near the end of their life, they were close to both the child in this case and his other child, and that they spent significant time with his parents because they weren't going to live long. They passed away in 2018. I think at issue here, at least what preliminarily brought about the need for this move, and what goes to another one of the factors the court looks at, whether the request was made in good faith, is the fact that this child has a long-term relationship with his grandmother who moved to start this business that my client is co-owner of and recipient of in Ms. Cox's estate plan, and is suffering significant and accelerated health issues that are impacting her ability to maintain the business, but also, I think, call into question the amount of time that she has left. And that is what brought about the need for my client to move in the first place. Another relationship that would be impacted here is the relationship that this child would have with his other half sibling. My client is pregnant. She has a history of complicated pregnancies, which facilitated the need for this move before she had all of her information about her mom's health. Her mother, in July, began heart monitoring, and they were waiting for information from a cardiologist to see the extent of her issues. But because of issues with insurance, Ms. Cox has still yet to see the cardiologist. There was an appointment scheduled referenced in declarations on August 10th that had to be rescheduled due to the surgeon's schedule or the doctor's schedule. So there's an acceleration of these medical issues that are forcing my client to act on a somewhat emergent basis with a relocation. And that is going to, if the court doesn't allow the move, have an impact on this child's ability to bond with his new sibling. The child's due date is February, and roughly the first 6 months of this child's life on proposal by father would be spent away from this newborn baby, away from an opportunity to bond with his sibling. So there's no question, and I don't think father's declarations suggest to the contrary, that there is a bond that is strong with grandmother. There's strong bonds with children and their grandparents. Unfortunately, his parents have since deceased, and the only remaining grandparent is in ill health in Arkansas. There's no prior agreement of the parties. Whether disrupting the contact between child and a person for relocation is more detrimental or not. Again, we're looking at it under the standard of best interest of the child. There are some things that can be gleaned from the declarations that I think support my client's position that she is functionally the primary parent, though they are on a 50-50 plan. When father, in his original declaration, is going through absences from school, there were more tardies last year from dad's time than mom's, more absences from dad's time than mom's, which contradict his wife's declaration. But one of the things that was noteworthy is referencing by dad that there were 2 days missed because of an oral surgery that was scheduled by my client. There's also reference to my client scheduling soccer and providing all the information and setting the child up for sports and activities. She is the parent who engages in those parental functions. He participates and is involved to the extent that he's able, and says in his declaration when he's not able to be there, his wife is there. But it does not change the fact that my client is engaged in that primary parental function. I think the other portion of the declarations that address the significant benefit to the child for the relocation is the quality of life, resources, and opportunities available to the relocating party in the current versus proposed geographic locations. In both the original declarations showing the information regarding the school district in the community in Arkansas that the child would be moving, and supplemental declarations showing the improvements to crime rate statistics and the quality of living in those communities, show that the move to Arkansas is beneficial to a significant degree. The schools are better, the retention rate, graduation rates are better, the crime rate is lower, and in neither the father's original declaration in response to my client's position nor in the supplemental really address that, other than to say generically that they're looking at a private school because their son is homeschooled. It's always a concern when children are chosen to be homeschooled versus attend public or traditional schools because of impacts on academic progress. And we don't have any information, neither side has presented it, to show what the half-siblings' education is like, having been homeschooled by Mr.'s wife. However, we do have information provided by the court that details the benefits that this child will have educationally in a school that has a low student-to-teacher rate, that has a high retention and graduation rate, and a community that has a significant improvement in overall safety and health. You couple that with what is an acknowledged benefit to this child. This is an outdoorsy child who has had a lot of time doing activities and on the farm that was owned in Toutle up until about 2022, where he had attended to chickens and goats, has a horse on grandmother's farm, and has the ability to engage both in the same scholastic pursuits or sport course pursuits, but in an environment that is better attenuated to success and growth, where a higher percentage of students are graduating and moving on, and opportunities to engage in what has always been an activity of value and benefit to this child, spending time outdoors on the farm, helping tend to the goats, having a horse, tending to the chickens, engaging in what is still an idyllic childhood, while also being able to maintain that significant relationship with his grandmother while she's still here while there's time. The alternatives are available alternative arrangements to foster and continue relationship and access to the other parent, or alternatives like an 8 and 9. It's certainly interesting. In this case, the summary of the position of the objecting parent is it would be a huge detriment to my relationship to allow the child to move. But it's not really that big of one to mom, because mom can have the summer and mom can have spring break, and we can work it out where time's relatively close to the same. And that is the exact same position that my client has taken in her proposal for a parenting plan. She's not trying to take the child away from dad or prevent dad from having a relationship. It is a function of where he spends the bulk of his time during the school year. And it's not quite 50-50 or 60-40, but with dad getting pretty much the entire summer, it is a significant amount of time along with every spring break and some fluidity to ensure that dad still has a chance and the ability to have a relationship, but where the day-to-day management of the child's life is administered by mom, because that's the person who's done it. And there doesn't really seem to be any disputing of that. It's really more a function of dad's objection is it could affect my time with my son and I want to be around, which is a point well taken for every parent. But it's it's not a situation where he is suffering a significant deprivation. My client's proposal was not to request support and to try and manage the cost of transportation. I think this was well thought out in an unfortunate, unforeseen circumstance where the combination of my client's mother's health and the pendency of a pregnancy that was not necessarily expected has put her in a position where she had to try and make a choice in a very short window of time, coupled with the beginning of the school year. Waiting 2 months to see details of what's going on with mom puts the child in a disadvantaged position to not get to school and get to the community when he's able to, as near the beginning of the school year as possible. So I don't think either parent is making an objection or request in bad faith, but I think that on the basis of the best interest of the child, when there isn't really an indication that there's any significant concerns or risks in the parent's household, my client has them. The GAL will look into my client and her mother identify their concerns with the person that was taken in through CPS and abuse, concern with the fact that Mr. has a pending misdemeanor animal cruelty charge in Columbia County. But I think primarily the biggest issue is the move is essential for my client. And so then the circumstance is in the best interest of the child to have him stay with dad and give mom the summers where mom has been the person who exhibits the primary parental function, scheduling, managing, setting dental appointments, setting doctor's appointments, getting him signed up for sports, providing records of the sports and schedules to Mr. and his wife, or whether it's in the best interest of the child to essentially uproot him either way to Rainier primarily to a new school and have that role taken on by somebody who has not generally exhibited that function during the course of the child's life to this point. It's not a permanent order. We're asking the court to authorize the move on a temporary basis. I have no objection to appointing a GAL to confirm the home situation, to talk to the child, to do everything that's ultimately necessary in a case like this. But at this point, the urgency is there because of the concerns for my client's mother's physical condition and her need to be engaged with her OBGYN where she's going to be delivering the baby because of her history. So we asked the court to authorize the move on a temporary basis, have no objection to appoint a GAL and essentially adopt our parenting plan on a temporary basis that would give the father spring break and essentially all of the summer minus what is a little bit less than the first week of school being out and the week before school begins. Thank you, Judge.
Thank you, Mr. Bolden. Ms. Cotto.
Thank you, Your Honor. So first of all, I would object to the court considering anything in regards to the mother's pregnancy. That was not contained in either materials or that it was a particular issue. So I would ask the court to not consider that argument. The bottom line here is this is a 50-50 plan that has been working for 8 years. And now all of a sudden, mom wants to uproot the child. And basically because she wants to, because she says that this relationship with the grandmother basically trumps everything. So this is why the child should be moved. And when you look at this particular case, first of all, what my client has told you in his declaration is he has been able to manage, he gets more time off with the child than the mother has. She works a 40-hour week where he was able to change his schedule where out of the 15 days he has the child, he has 10 days off. So he has a lot of time with this child. So it isn't just a matter of completely disrupting or moving the child. It would be a huge impact on the child. So all of a sudden, a dad who he sees all the time, a brother that he sees half the days of the month, family that he sees in Rainier, Oregon, that he sees all the time, that he has built a relationship with, he's taken from that. Plus he has relationships locally. And so all of a sudden, we're going to move this child across the country to Arkansas. And I can tell the court that Ms. Quiros is dreaming if she thinks that she can get a flight from Memphis to Portland for $300. Not going to happen. And it also will take a full day. There's all kinds of rules with unescorted or escorted minors where they can't fly the last flight of the day. The child will have to fly through either Denver, Dallas, or Chicago. It's a 2-hour drive to Memphis. So in that respect, it isn't going to be just an easy either way. But to say that there's a easy travel for the child and you can spend time with dad, that makes absolutely no sense. There's going to be extreme disruption in the relationship with the child and with the closely bonded family that my client has locally. His wife has family that's been involved with AJ since his birth, or since my client's been allowed to see them. There was about a year where Ms. Quiros would not allow the child to see the father, and then we were able to go to court and get that. But since that time, which I believe is the summer of 15, my client has had a lot of contact. when counsel argues that, well, mom does all of the parenting decisions and therefore takes the primary role of the parent, what she did is she signed the child up for a sport. My client felt like he did not sign the child up for a different sport because pulling the child in too many different directions, he wanted the child to have time with the family, time for homeworks, time for things like that. So he didn't sign the child up for another sport. It isn't that he wouldn't do it. It's just, as he tells you, you can put too many things on a child's plate. He wanted his son to have time with the family. He respected and made sure that the child made the practices and he made the games. But that wasn't giving that function over to mom. Mom took it upon herself. She signed the child up for one sport. My client felt like one was enough, and he honored that. As far as the dental appointments, that's been back and forth. Sometimes she had listed herself as the primary parent. She made some of the appointments. My client made some of the appointments. In those particular, the 2 times that the child was not or had a medical appointment, she did make that appointment. But you don't have, in this particular case, you don't have a child that's had a lot of tardies. I mean, 4 tardies or 5 tardies all year is very good. Not a lot of illnesses. These parents have been cooperating for years. And now all of a sudden, this is an emergency. And I would submit to the court, this is something that's been planned for a while. If you read through the grandmother's declaration, she's buying a horse for the child, talking to the child about, well, isn't this great? You're going to be living here. And so they've been planning this for some time. My client gets this short turnaround for this alleged emergency. And I would also question the emergence of this. You know, my grandmother says she's had these health issues for years. She gets a farm, she sells her farm, and then she gets a labor-intensive farm when she's in a wheelchair, when she has these heart problems. That makes absolutely no sense. The farm has a lot of work. Why would you do that if you are having those particular health issues? So we would submit to the court that this was a planned event, that we acknowledge that the child is close to grandmother, but it is not the basis for taking the child from everything the child knows. My client and the child spend a lot of time together, contrary to what Ms. Quiros is saying. Well, he's working a second job. He is not. He works it's a little more than 40 hours a week, but it's a 12-hour shift. And we provided that schedule to the court. And that during the time he's with the child, they're doing things. They have family activities. It's pretty obvious, too, that the child's being pumped for information when both the grandmother and Ms. Quiros make all types of statements and say, well, the child says this, and the child says that. When you start quizzing a 7 or 8-year-old child, they don't want to talk about it, then they're going to tell them what the other parent wants, or they're going to say sure, or they don't want to be part of this. And one of the things we are asking the court is that there be no discussion with the child. It's pretty obvious that the child is being pumped, that there is information that they shouldn't be talking to about the child. And we agree on it on both sides. There's new information that we didn't know about. We didn't know about the mom is now claiming, well, I'm going to have this high-risk pregnancy. The court shouldn't even consider it. My client's version is AJ is very happy with his mom, with his dad, with his stepmom. My client is not controlling. If he was controlling, as claimed in the declaration, you would have seen him putting his foot down to what the sporting event. And what he did was, mom wanted to sign the child up. My client agreed. One of the things the court's seeing is basically throwing out all the mud, see what sticks, and get the court to order that there's a complete disruption of this relationship with the child, not only with my client, but with the entire Pacific Northwest family. There's an extended family. There are opportunities here. And I realized that Ms. Quiros provided all of these graphs to the court. You can get anything off Google. I would submit to the court that you might have some of this, crime information. I would submit to the court, first of all, this is for Longview, and my client lives in Rainier, that Longview has good schools, that Kessler is a good school. In fact, Ms. Burrows is the one that moved the child from Tootle to Kessler School. And now all of a sudden it is the worst school in the world when there are other schools that he could have been signed up for. My client has no doubt that the child is close to his grandmother, that he loves his grandmother, but that isn't the only issue here. This change would hugely impact the child negatively to move to Arkansas, of all places. It isn't like it's moving 2 hours away or 4 hours away. And to say, well, you can have the summers and you can have this time and it will make up for that. Well, it doesn't. And I understand that we're kind of arguing the same thing on the flip side, saying, well, mom can have this time, but you still have, she's making the active choice. She is leaving a very good job. Her fiance is leaving a very good job. Understand that her mother's got some health issues, but questioning, you make this move. I think that this is something that was thought about a long, long time before. This is really has a huge impact on the child. I think if the court reviews all of the information, that there is the presumption to keep the schedule of a 50-50 schedule. And one of the things that's interesting that Ms. Quiros asked for, she says, well, I shouldn't have to pay child support, and I should get 120-day credit because I'm going to have this child more. That again shows that she really isn't concerned with the best interest of the child. What she's just wanting to do is, my mother wanted to move. We want to pad this as best we can. This has been planned for some time. My client has been a significant impact with this child's life. They do a lot as a family. There's not a lot of formal sporting activities, but sports is not the only piece of a good family. A good family that spends time together, that shares, that has activities. My client does that with the child, and he spends significant time. And to take that away from the child, just saying, well, you're going to move to Arkansas because your grandmother's ill. My client indicated in his declaration, he doesn't have a problem with, if grandma's really ill, sending the child to Arkansas to spend time with the grandmother. But this is a move. This is a move that will completely remove the child from everything he's ever known. There's really isn't any true good solid evidence that says it's so much better in Arkansas. You've got a couple report cards from, well, this Cedar Ridge school is great, but that really doesn't tell anything. I mean, this is the first time my client heard that this was a possibility, and to research that, to call Cedar Ridge, to look at the community. There's been no time to do that. The GAL needs to look at it. The child needs to stay here, stay in a home and an area where he knows people. Ms. Guerrero's, if she chooses to move, she can move. But this is really, the presumption should be to leave the child with the father, because this is everything that the child's ever known is the Longview area. There's no indication that it is not in the best interest of the child. There's no indication that the child's had any struggles. You hear from the grandmother who's got a vested interest. Oh, he's unhappy. My client tells you the opposite. So, having a GAL look at this before any move is allowed would be appropriate. And we would ask the court to deny the request. We can work out some, holiday visitation. But at this point, to do this at this short a notice without having any investigation other than, presenting to the court all of this information and how great an opportunity this is really premature and should not be allowed. So we would ask the court to deny the request, and that if Ms. Guerrero's wants to go, we have a proposed parenting plan, which we provided to the court, allow the child to move over to Rainier to be with my client, and keep the child here. Thank you.
Thank you, Ms. Cotto. I have a couple questions, and I'll obviously give you a chance, Mr. Baldwin, to respond.
Sure.
When I reviewed everything, I did see there was a sealed confidential reports with some healthcare information with regards to grandma. I'm reviewing that, and the most recent update is
I thought it was
6 months ago. Yes, I think March 20th, 2023, and it doesn't indicate any, I guess, and to be perfectly fair, a lot of the ailments that are listed on the initial, so I'm looking at page 2, and I'm not going to go into it too in depth just for, privacy's sake, but it's I don't see the dire need, I guess, based on the medical information that's been provided. The 4 things listed on page 2 of index number 56. And I know that this is about this is from about a year ago, I believe, when I looked at the dates for this.
That's correct.
This isn't, and frankly, I can't tell from the remainder of the information, especially since the most recent thing is 6 months. But the most detailed thing is almost a year old. And we're in a small community. I know a lot of people are aware of this, but I'm very familiar with these illnesses. They are something that's pretty dominant in my family and impacts part of my family. And I guess other than the fact that this woman chose to purchase a farm and is claiming in her declaration that she's needing to, vaccinate animals and essentially carry out farrier-esque duties with other hooved animals, and that she's often in a wheelchair. I don't know. I guess where's the dire circumstances other than she just needs help? I guess that's what I'd like to if there's more information there. I've also reviewed, obviously, the grandmother's declaration, a little concerned about some of what I'm reading in there, but I guess, am I missing anything?
Your Honor, it's unfortunately in declarations, primarily my client's original declaration, as well as at least generally addressed in grandmothers. The information we were able to obtain from the visit summaries, the June 20th was for the historic issues that had been ongoing that are addressed in my client's initial declaration. That's the list of 4 items that were on the page of the note that shows progress note, June 20, 2022. There was an incident in March that was addressed in my client's declaration, I believe, and I think it was also in Father's, but I could be mistaken. My client had to go out to Arkansas in March because of the issues with her mother's health that are addressed in the March reports. The declarations reflect that within the couple of weeks leading up to the filing in July, that Ms. Cox ended up having to go into the hospital and be placed on persistent heart monitoring because of cardiac issues that were exacerbated from her other problems. The reference in the declaration was that she was scheduled to have a follow-up with a cardiac specialist on August 10th to interpret the results of that and to address the future plan. That was the information that we were anticipating would show the further diagnostic concerns that resulted in her being treated essentially in the emergency room for cardiac issues. As I indicated in my initial argument, that appointment ended up having to get rescheduled, and I don't have any records that are more current that reflect those cardiac concerns. It was that cardiac event coupled with what occurred in March, resulting in my client taking time off work to go tend to her mom, that, again, because of the limitations in some space, some things had to be kind of pared down in the declarations due to the page limits. The declaration that was filed wasn't able to go into a lot of detail on beyond the fact that she had cardiac episodes sending her to the hospital requiring persistent heart monitoring and a follow-up with a cardiac specialist to determine the course of action from there on out. And then Ms. Cox's declaration that she, as a result of these issues, not just the 4 items listed that were historic medical conditions or concerns, but the what she called flare-ups that resulted in her heart monitoring and her needing to see a cardiac specialist are what has created the somewhat emergent need. The concern that both Ms. Cox had and my client had with her having to be placed on a persistent heart monitor and the lack of certainty about a cardiac specialist because of her insurance certainly added to the concern, but their indications are that this is urgent and pressing. So that's what brought about the filing. It, I think, cuts against the accusation this was a planned event. If it was a planned event, we would have more information. Unfortunately, this is something that is just happening in real time around my client and her mother that put her in a position to have to come to court now. I would much rather have had the cardiac appointment held. I would much rather have the information from the cardiologist about what the interpretations are of the heart monitor. We don't have that because that's not the situation we're in. We had to file it when we did because it was, as expressed to them, urgent or emergent severe health concerns that she didn't want to wait until 3 months into the school year and then be asking the court to do this, because that's not what's best for the child. What's best for the child is to address it now. So I believe the declarations are sufficient to establish what the urgent need is for my client's mother and why they're moving. I don't.
Your Honor, if I could just make one point as soon as Mr. Baldwin is done answering that question.
Ms. Cotto, I'm done answering the question.
Well, I just want to point out that there's a letter in there from 7/31 of 2023 that says limitations for physical education, and a patient is wearing a heart monitor until 8/10 of 23. Heart issues are really serious, and so they don't mess around with these things. So I would submit the court has a pretty good take on actually how significant or how severe it is.
And yes, my only response is they care an awful lot when people have insurance set up to cover and pay for it. When they don't necessarily always care all that much. And my client's declaration identified that the delay in her seeing a specialist was due to her mom having issues with her insurance. So that's why we don't have the information we wish we had.
All right. I appreciate your responses. Mr. Butler, any other response to Ms. Cotto's statements or any other rebuttal?
Yes, Your Honor, just briefly. As first, I'll address regarding the pregnancy on page 2 of 4 of my client's declaration, line 25. Again, summarized because of length. My fiance and I have one child together, and I just found out I'm expecting a second. That pushes us to make a decision to move sooner than originally considering so that I can engage in prenatal care in Arkansas as early as possible. I'm currently 8 weeks pregnant and due February 27th, but I have had complications with pregnancies and have preemies, premature babies. So it is included in her declaration that was one of the considerations resulting in her needing to move, specifically that it pushes to make a decision sooner than originally considering, because this is information that was just found out. So I don't think that it's inappropriate or not properly before the court. It's listed in my client's declaration as a consideration or concern. There's a dispute about the extent of father's family involvement with the child. My client recounts that he and his brother had a falling out, that there really isn't significant family. He focuses, it seems, in his declaration a lot on his wife's family, and they are certainly around and involved in the child's life, just like my client's fiance's family is here, and like grandma is in Arkansas. The issue here isn't even exclusively why is mom moving, though the declarations, I think, indicate a number of factors that put her in a position to do this now as opposed to at some later point in time. The issue is what's in the best interest of the child. The fact that mom schedules doctor's appointments, that mom signs them up for sports, the dad doesn't do those things, isn't, and I agree, evidence that mom is the one who has the sole authority to do so, but it shows an abdication on the part of dad to mom to do those things. And an issue here in determining what's in the best interest of the child is which parent is in the best position to ensure the day-to-day care of that child is met. Is that mom or is that dad? The history here that I think both declarations show is that's mom. And we're not talking about a presumption. There's no presumption in favor of a move because the current parenting plan is 50-50 and there's no 191 factors. We're looking at a situation that is just squarely what's in the best interest of the child. Either way, there's going to be a detrimental impact to a relationship this child has if my client has to move and has to move without him. There's no way around that. There's no situation where there isn't a potential where daily contact, regular contact is affected. It can only be mitigated. The issue is whether it's in the best interest of the child to move with my client or not. And I think here, looking at the declaration and the facts that all dad can really say is, I didn't sign him up for other sports because one's enough. Kids don't specialize generally at this early an age. Though none of this is in the declarations, I guess neither is the information that was argued by Ms. Cotto about transportation costs and flight routes and all this other stuff. So I'll just say, kids play more than one sport. Kid plays soccer in the fall and softball in the spring and maybe runs track. It is an indication of some of the concern my client expresses. The dad's position is, one's enough. It's an effort thing. And even though the order is historically joint decision-making and it is a 50-50 plan, dad gave mom the authority in action and just abrogated his personal authority to ensure that the child engaged in sports or went to doctor's appointments. Mom did those things and will do those things. The parent who does those things is in the best position to ensure that this child is taken care of in the general day-to-day life, to make sure he's in school, to make sure he's in class, to make sure he studies, to make sure he does the things that he has to do. Yes, it's fortunate that both parents care deeply for this child. I think that's clear. It's not a question of do these parents love their child. It is, in a situation like this, is it in the best interest to allow the child to move or is it in the best interest of the child to stay? With the significant bond to his grandmother, there is a benefit to the move that doesn't exist if he stays. He's bonded to his dad, he's bonded to his mom. If he stays, the bond to his mom is affected. The court can fashion a plan that reduces that, just the same we tried with dad. But the reality is you stay with one parent, another parent leaves, you go with the parent, you stay. There is an impact. There's no way around that. What we have here is a situation where the impact is severely lessened by going with mother because of her involvement in the daily aspects of the child's life and what the role of the parent is during the school year versus what the role of the parent would be in the summer. It is in the best interest of this child to maintain that relationship and continue to grow it with his unborn sibling and to spend the time that he can with his grandmother. Again, dad referenced in his responsive declaration from yesterday that it was important to spend time with his parents when they were in failing health because they stayed with them and the kids were with them. And that was a bond and time that was necessary for a child. This was in 2018 when the child was 4 or 5 years old. Instead of now, 9, 10. There are bonds and memories he's going to be able to make with this person who everyone agrees is important in his life. And that coupled with the improvements to the school, again, the declarations show the school was 10 kids in the classroom. The student to teacher ratio is better than even the private school. Dad is mentioning with some detail in his responsive declaration. There are benefits that are significant to this child outside of just the fact that he'll get to spend time with his grandmother, in addition to his mother. And the court is able to mitigate the potential detriment with dad with a parenting plan that gives significant time in the summer and allows him to be an active part of the child's life. So that's what we're asking the court to allow. Temporary basis, allow the move, because it is in the best interest of the child based on the evidence contained in the declarations. Thank you, Judge.
All right, well, there's one agreement here, and that's that a GAL needs to be appointed. So if the clerk could give the next three names on the list, please.
The next three are Heather Kell, Amy Turnbull, and Ann Height.
Mr. Baldwin,
So, Judge, I'll strike the first.
Heather Kale.
Yes.
Okay, Judge, I'm not prepared to actually jump in and do this because I have been away from the family law arena enough where I would like to talk to somebody. And then I can, before I make that decision.
Okay, so we have Amy Turnbull and Ann Height as the two remaining. So I would just, I'm assuming the parties could work together to prepare an order and submit it ex parte once you've had an opportunity to do that, Ms. Cotto.
Yeah, that would be fine.
And the quicker we can get that done, the better, but I understand the request, so that's fine. This is to be frank, this is a kind of an awful situation. As a judicial officer to be put in, this is a 50-50 parenting plan that has been established since 2015. I have an immense amount of sympathy for ailing parents and wanting to spend as much time with them, going through that, help them, whatever. I understand that. I am a little concerned with the amount of information that's been provided and how imminent any kind of, I guess how mitigated these issues could be. This individual is only, I think, 65 years old, if I did my math right, or about to be 65. So there's nothing that I'm seeing that says there's an imminent, impending health concern that really would push this move. However, I also understand that there are some physical limitations and that the agreement between the parties and the ownership of this farm or ranch and the duties required for that and the limitations that she has. I also understand that there are other health concerns that the parties weren't able, or excuse me, Mr. Baldwin wasn't able to kind of supplement the record with that are still kind of awaiting some test results. I do not like the fact that 50-50 plan, everything's hunky-dory, but it's time to move. And now all of a sudden dad's a bad guy because of this, and this. That doesn't smell right to me. It's concerning a little bit. I do see the difference in schooling there. I understand the arguments of all parties. We will get a GAL involved, and really what the court's determining at this point is on a temporary basis, is the move approved or denied. I have reviewed 2609-520. There's 11 factors the court has to consider. And frankly, the majority of these are a draw. I don't know that I can indicate that there's a stronger relationship with one of the parents, any of the siblings, any of the other individuals in the child's life. There doesn't appear to be any prior agreement of the parties other than to the 50-50 plan. Would it be more detrimental to not allow the move? That's hard to say. I mean, obviously, life is fragile and we often take it for granted, and who knows, what the grandmother's condition entails and where that is going to lead. There's no 191 factors in this case. I'm disregarding that. If there's good faith of each of the parties requesting, and I know that there's some current concerns with that, whether it was kind of last minute or whether it was pre-planned. I don't know that I have sufficient information to make that determination at this point. I did read the information about the small school that's available in the area of Arkansas that the move would be taking place. Do I know that that's better than any school that the child may attend in Rainier? No. Quality of life, resources, opportunities available. We're both in smaller communities. It appears that the Arkansas community would be significantly smaller, given the number of folks in the school, just based off that. Just taking judicial notice that it sounds like this town is approximately 2 hours from the closest airport versus here we're approximately 1. Alternatives to relocate, financial impact, and how long it would take before final decision could be made if a temporary order is granted. So I'm taking all those factors into consideration. I don't think there's I don't think any one of them is standout that says one side or one thing should be done above the other, to be very frank. Both parties make very good arguments. Clearly, these are parents that are involved in this young child's life and want the best for him. There's connections to him here, for him here. There's been clearly most of his life has been spent here. The kind of idyllic life on a farm idea and having chickens and goats and horses clearly is, one of those, maybe childhood idyllic situations. I don't know that, to be frank, I don't think anything is really sticking out as a prevailing reason why this should be granted nor denied. Do we have any additional information on school schedules? If the move were granted on a temporary basis, do we have any idea? The reason I'm asking is because I have family that lives in that area and they have a fall break. It's like a Midwest thing. I don't know. So that's like a week-long vacation in the fall, and that's on top of Thanksgiving and the winter holiday. Do we have any of that information?
I don't have it in front of me, Your Honor. Unfortunately, I can ask my client real quick if she is aware. I know she's here. I thought I recall my assistant mentioning that to me, but it was not specifically added into the parenting plan, so I can't say for certain.
Okay. And I know, Ms. Goto, you probably don't have that information either.
Well, I do have a lot of family in the Memphis, the Tennessee, Arkansas area. I don't recall the cousins having breaks in Arkansas. The winter breaks. I recall just the normal breaks is what my recollection is.
All right. Here's what I'm going to do, and this is difficult. So I understand one side is going to be probably devastated by the court's ruling today. I'm going to allow the move on a temporary basis. I'll appoint a GAL as soon as Ms. Cotto is able to review that. What I would like to do, however, I see the proposed parenting plan, and I'm assuming we're still working off the one you filed on the 8th of August, Mr. Baldwin. There wasn't a secondary.
Yes, Your Honor. Sorry, I was muted. I was trying to pull up the Cedar Ridge School District. I know my client indicated that she provided my office a calendar, but I didn't have it in front of me. So I was trying to check that as Your Honor was ruling. But I did not file any additional parenting plan.
Okay. So here's what I'm going to do. I don't know how quickly there's an anticipation of leaving town. I don't know if you are aware of, based on the ruling today, how quickly your client and her family were anticipating leaving.
They were anticipating leaving quickly, Your Honor, because school was just starting here and I think started there last week. We set the matter over because of the short notice from Ms. Cotto. So I know their intention was to move relatively immediately upon the court's ruling. But if Your Honor was wanting there to be a lag where he had additional time with his dad for a week or two prior to the move, I think that likely would be able to be accommodated. Trying to anticipate what Your Honor was going to be suggesting.
Who's currently, who's the child residing with currently?
It's with the mother.
Okay.
And we would like some more information because we don't have any dates. We have nothing other than, well, we want to move right away. Since the court's going to allow the move, we would ask that the child be transferred to my client until the move. We get the dates and that my client gets to have as much time with the child before the move.
That's exactly what's going to happen. So I'm going to, and if that can happen today, then I want it to happen today. So, and then I'd like for father and his family to have, it's Tuesday. I'd like him to have at least a week with the child before the move occurs. I know that delays things, but there's a lot of registration and stuff that can happen long distance, hopefully. So I guess the move cannot occur before the 6th of September. If there's a date that they have after that, that's fine. But I want a father to have the child at least through the 5th. If they are going to move on the 6th, then the child should be returned to mom morning of the 6th. Hopefully parties can work out the numbers there. I also am going to, because we're going to set this for a full hearing, I'm going to just sort of look at what we've got going on for the rest of this, at least calendar year school wise. I do see that the proposed parenting plan has odd numbers years, which we're in. So any winter break would be with dad. And that would be,
can we have the child from the time school gets out through the entire break?
that's what the proposal indicates.
Okay.
So, and that's just, and frankly, until we get this to a full hearing, I want to keep it that way. I'm hoping that wouldn't last for two winter breaks worth, but dad gets winter breaks until this is resolved. From day after school is over, and it does indicate, or as soon after as possible with weather. I don't know how much snow Arkansas gets, but as soon as possible. So it should be the day after. I understand it's going to be a very lengthy travel day for this young man, but it needs to be as soon as possible. And if it needs to be the last day of school, we need to make sure that dad gets the child for all of the winter break and is returned no later than 24 hours before school resumes. I'm also authorizing dad to have Thanksgiving break. Wednesday through Sunday of Thanksgiving. And again, hoping this doesn't last through next year, but that would be until this is resolved.
Your Honor, I apologize. So I was able to get, my staff ran me a printout of the school schedule. There is not a full break in the end of the first quarter. There's a long weekend of the Friday, Monday in October, but it does appear the school takes the entire week of Thanksgiving off for Thanksgiving break. That may be what Your Honor was contemplating. So the school schedule that was provided to me looks like the Monday, the 20th through the 24th of Thanksgiving is off for school. So that might be what Your Honor was meaning or recalling. So I want to make sure I provide that to the court.
My reference point is Missouri and Ohio, so it could be different in Arkansas. But so let's change Thanksgiving instead of Wednesday to Sunday. Let's do Saturday prior to Sunday after.
Okay, so the entire Thanksgiving Day break.
Yes, so the days prior and through the weekend of.
Okay, and I hate to ask this of the court, but because of the way the court schedule goes, if for some reason we go into the spring, we would ask for the entire spring break. I don't know. I don't have the school schedule in front of me.
I happen to. It was in our proposed parenting plan of the whole spring break. Looks like spring break is March 18th to the 22nd. So I don't know if the court wants to just say the entire spring break from Saturday to Sunday or those specific dates, but those appear to be the dates of the holiday.
Let's say the entire spring break, Saturday to Sunday to father.
Okay.
And then I guess I do want to hear very briefly, their proposal, Ms. Cotto, is in lieu of any child support payments that dad would pay flight costs to and from. I don't know if that's something we can resolve today or because I mean,
the flight costs are going to be pretty expensive because you're going to have to pay the unescorted minor, which is $100 to $150 each way.
I unfortunately am aware of that. And it could very well, here's what I'm going to do. I'm going to reserve on that. So at this point, I'm not making any finding of child support. Mom is making this move and forcing this issue that I'm not going to require dad at this point to pay any child support. We're going to reserve that for a hearing. And I'm going to, as far as paying for the flights, I'm going to have mom's going to pay 65%, dad will pay 35%.
And I apologize when I was about to just ask it with the first flight not being until November for Thanksgiving, if the court was reserving on support, I just asked the court to reserve on flights so we can put it in front of Your Honor with financial information and have a hearing. But
If I'm fine doing that. If Ms. Cotto, you want to present some financial information regarding that as well, and we can actually look at what costs would be.
Yeah, because my problem with mom is she's the one who's leaving a very good job, and then she goes to no job, and my client then gets stuck with paying
No,
the child's support.
I understand that, and that's something that I definitely will be considering, and the respondent in this case should be aware of that.
The other thing is want to make sure that there's a significant video and phone contact with dad and child.
I would absolutely agree to that. I don't remember reading in the declarations that the child has their own iPad, phone, iPhone, cell phone, but child should have very liberal access to phoning family in Washington, FaceTiming, whatever is available to him, and however often he needs. I'm sure mom is aware how significant this move is, and child will need to be able to talk to dad and stepmom however often is necessary. That should not be limited unless it's interfering with school or sleeping, and I don't want that to be limited unless there's a really, really good reason for that.
And my client indicated he has a phone. Our proposed parenting plan did have the child shall have liberal to low. It said local. It shouldn't be there. Should be struck out. Telephone is not.
Mr. Baldwin, I can work a lot about the finer points about, and so I'll talk to Mr. Baldwin, and if there's an issue, then we can put it on before Your Honor.
All right. And then I'm assuming financial wise, do you want to just note that up? Or do you want to set a date for review a month or two out today?
We want to set it for, sorry, go ahead, Ms. Cotto.
Let's note it up because I have no income information from Ms. Boyros at all.
Okay.
All right.
And then if we could get the GAL information or order appointing GAL by the end of the week, so the GAL can get notice and start working on their portion as well.
I'll talk to other counsel and I'll get with Mr. Baldwin right away. What is the percentages as far as paying for the GAL? Are you going to keep it to 60-35?
Well, at this point, because of the situation that we're in, I'm going to say 65 to respondent, 35 to petitioner.
Okay.
And then, so I'm going to set that at this point.
Okay.
At that, but that may, well, not that won't change, but potentially with more financial information, other decisions moving forward could be different than that, I guess.
Okay. All right. Understand.
All right. Good luck.
Thank
you.
Okay.
You have
Thank
time.
you.
All right.
If I had time, that would be great. That's right now is my time. Okay. Rance and Vic, Ms. Baldwin beat everybody to the punch here. So we are here on a review hearing.
Yes, so two things. We're here to review ensuring that the guardian ad litem report had been filed, and second, to address the current restraining order. So the court had entered a temporary restraining order and sent it over to today to essentially review that in light of sort of the guardian ad litem as well as the child being in counseling. If the court will recall, we were not with the guardian ad litem report. Guardian ad litem's on board. So the court will recall the last time we were in front of the court, the court had some concerns about the visits and how visits were going. The court paused essentially father's visits for 2 weeks, set things over in this case to review and review father's visits, ordered the child to get into counseling. So a couple things that were filed, both parties submitted declarations, and then sort of last minute, there are two filings. One is the filing from the mother filing some documents from Columbia Wellness. I don't know when that was filed. It was signed the 27th. We submitted today, additionally, essentially a copy of the information we received. So at the last hearing 2 weeks ago, the court ordered the counselor's information to be provided essentially immediately. And we provided you the email that we got from opposing counsel. So where we are is we've paused visits and we're here to review what we're doing here today. Concern here is child's not seen father now for 2 weeks. So my client, we've been doing a long reunification process. The court will recall this case started in February of 2020. We've been pending essentially 3.5 years at this point. The record shows in July, based on what was submitted by opposing counsel, that unilaterally, without any joint decision-making or discussions with my client, And contrary to court order, the respondent mother takes the child to a counselor. My client doesn't even know this is happening. A counselor provides her report that's submitted here. Of course, we never see this until now, until it's provided just now. The counselor says, well, I've called father. He didn't respond. My client didn't even know this was happening. We don't know what number, if any, was provided to the counselor. So again, real challenges there on, and even if a random call from Columbia Wellness comes in from my client and he gets a voicemail, why would he respond to it? In the sense of, how would it be relevant if you just get this random call from somebody that it's not in counseling to my client's knowledge? Then we move forward. We have the court orders, the counselor's information to be provided and for the child to be placed back into counseling, essentially. We have the email that they've submitted essentially saying child doesn't meet the qualifications to continue counseling. So no, we're not going to do that. Concern here is that the information provided to my client that he would have reached out to was a completely different name than what the actual counselor's name was. The name that we were provided with was Bethany Pollard, not Stephanie Pollard. Those are two very different names. The spellings of the last name are even different. So again, we're provided the incorrect name, incorrect email to a counselor that's been engaged over a year, or not a year ago, been engaged more than a month prior, that my client had no knowledge even existed. So again, the idea that my client can even try to connect with a counselor, it's impossible. This is just further obstruction. And again, the court has to recall where we were. Back in December, child and Mr. Had been working with Charlotte Rosen for approximately a year. Visits were going really well. Visits had been expanded by Charlotte Rosen. They were doing these visits where they'd meet at her office and then sort of off they go for the day, come back. No reported issues from anyone, not Mrs., not Mr., not the professional reunification counselor. Everything's going well. Charlotte says we need to expand to overnights. Everyone agrees. Mrs. then says, no, ratchet it all back 2 hours in the office, completely supervised. Again, then it takes my client time and funds to be able to get back into court. Meanwhile, Mrs. files to relocate. My client objects. Suddenly, child's visits are going terribly when the court expands my client's visits. So we go from a child that's doing fine and having great visits to a child that's angry, that is reacting poorly, that's running from my client and calling 911. And the clear indications from 911 are that child's being coached. We have my clients being able to hear mother directly coaching child.
I'm going to object, Your Honor. This isn't in the record. We're here to review counseling records. I think every time we're in court, we go through 2 years of history.
We're here to review the pause, and that includes all of it. So the court paused. It wasn't just, hey, is he in counseling? The court paused and suspended my client's visits. We're here to decide what we do for visits going forward. So all of it is very relevant.
That is not my understanding, Your Honor. Your ruling was very clear. Child to see a counselor, file the counseling records. We come here for a review.
I disagree. You said we'll get information, we'll come back, but and you said I'm not just going to leave this paused. Counsel wants to act like, hey, you paused it permanently. Don't even consider anything. Just, confirm the kid's in counseling and move along. That is not what we were doing.
That's not true. I'm deferring.
My notes indicate and the minutes indicate that I did a 2-week pause on visitation to get an updated information on counseling, and that the hearing on 8/29/23 would be to review those counseling records and set visitation moving forward. So go ahead, Ms. Baldwin.
Thank you. So we see suddenly these visits where, again, my client can overhear mother coaching child. Well, didn't you tell 911 this? Well, then if they don't do what you want, then tell your grandma this. Call these people, tell them to do this. My client can overhear her on the phone. So this isn't a he said, she said, or hearsay. My client directly heard opposing parties say these things to child. And frankly, Mrs. doesn't dispute it. She doesn't deny it, that this is what she's doing. That has to be viewed also in light of the motion to compel that's been filed. And that's one of the reasons why my client wanted that to be considered, not in the sense of you're going to make a ruling on that, but in the sense of the phone is being used as a tool to manipulate the child. And that Mrs. is using that to alienate the child from father. If I didn't get what I want, I'm mad that these visits are going forward. Let me continue to obstruct using the child's cell phone, because these are the direct records that they're refusing to provide, which are the records that would indicate exactly the extent of the interference by mother. Again, we see the records from Stephanie Pollard. And even if you look at those, what is child saying? Child a month ago, essentially when all this was supposedly blowing up, dad isn't coming into the fact that his dad's coming into my life is not causing the issue. This is the direct words from child to counselor. Dad isn't the problem. Child denies anxiety, basically says, hey, these weekends are interfering with some of the things I want to do. And otherwise, this is not, doesn't have anything to do with dad, his family, anything dad says, does. So there is nothing in that record that's been filed that indicates any wrongdoing on my client's part. So again, a significant concern here. It's also concerning that essentially mom co-ops that visit. If you look at the paragraphs of what they filed from the schoolyard, it's essentially kid's going to do the intake, but mom says, no, 13-year-old can't do it alone. I'm going to come in and I'm going to tell you what the problem is. Then counselor meets with child, and child basically like denies, like says, no, that's not what's going on. Like I got into a fight because I was defending another kid, not because something's wrong with dad and me. When child denies the problem, mom then comes in a second time being like, no, this is really the issue. So mom's clearly trying to sort of push her agenda on counselor. I'm concerned because counselor says essentially she validates mom, which I think is like, oh, you're right, kind of a thing. But again, there's nothing there that supports continued suspension for my client. The concern here is we have Charlotte Rosen for a year. So we do have the professional reports of Charlotte Rosen, all of which are positive. Dad's on track. There are no concerns with dad. There are concerns with mom that Charlotte Rosen specifically calls out saying, hey, I do have some concerns on what's going on with mom, but for every hoop, dotted every I, crossed every T. Meanwhile, child isn't doing so well with mom. When we look at mother, who has the child 99% of the time, child's missing school, child's getting into fights. We have domestic violence in the mother's household with a police report to verify that. We have her relocation to a mobile home in Cathlamet. We have her not working, no evidence her significant other is working. So we have two adults with no clear income coming in. We see really chaos in mother's home, but all mom does is just go back to the same well of let's blame dad, must be his fault. Hey, he's a felon. Gee, he does drugs, but doesn't provide any evidence of this. Like my client says, yep, I committed that felony, paid for it, turned my life around, doing all the right things. There's already an order that mom can drug test my client at any time. And the only time she's done so, my client went and did it, and then she refused to pay, even though it's a loser pays order. And we, in fact, had to hold her essentially in contempt for that and order a judgment to get her to pay it. What we do see in this case is obstruction. We see 3.5 years of obstruction of her saying, when my client was incarcerated, you can't even send letters to this kid, even if mom could have opened them and looked at them and read them. I refuse for you to even have that level of contact. For my client has done everything to fight his way back, take parenting classes, first aid classes, AED classes, become a supervisor, go out, get a job, be working, completing probation, literally doing everything possible that this court has asked him to do just to be in his child's life. And what we see on the other side is repeated contempts, repeated compels, repeated orders to comply over and over and over again for 3.5 years. It is not reasonable. I understand the court giving a parent grace periodically and saying, hey, maybe you didn't sort of get up to speed fast enough. But after 3.5 years, that has to come to an end. There has to be an end. It has to be an end for this child. We started this case and this was a 10, 11-year-old child, and now he's 13, 14 years old. We're looking at a kid who's going into high school, and it's just not reasonable to continue the path we've taken and to allow this repeated behavior with mom just saying, I'll just obstruct. It works for me. Don't really get held to account for it. It's not reasonable. So my client, again, is not being unreasonable. He's not asking you to switch custody. He's not asking for you to sort of do something dramatic. It's basically asking you to stick to the order you already made, that at this point in time, my client should be exercising his visitations Friday to Sunday. Second, we're asking that the child's phone not go with him. The child's phone is being used as a tool for alienation and allows mom to just repeatedly peck at that child the father's entire visit. That is not appropriate. It's not working for the child. At this point, given his age, he can self-help if he needs to. He can use any phone that's laying out, any iPad that's laying out to call 911 if that was the situation. But that's not what's happening. What we have is a child and a mother who are using that phone to alienate. So no phone on the visits. My client is asking for fees. This is a situation where my client is somebody who struggles. It's very hard to come out from incarceration. He's done an amazing job, and much to his credit of sort of pulling himself up by his bootstraps and doing all the right things. But when you look at it, and it's important to look at that pattern, and I didn't even go through all of it. I mean, counsel sort of doesn't like the recitation. She doesn't like it because it's bad for client. Because when you go through that long history of contempt, compel, requiring mom to comply, when you look at the history in a totality, it's really, really negative for mother. And it's very clear that she's alienating and obstructing. She just doesn't want this to happen. And the reality is that at some point we need to have regular visitation, and at 3.5 years, that time is now. So again, we're asking the court to essentially just hold to the order that you already made. We need to just go straight to the regular visit pattern. But again, with the caveat of the phone shouldn't go, with the caveat of these are reasonable, because when you look at the totality, it's the mother here that's obstructing.
Ms. Jeffers.
Oh, Your Honor, I kind of feel like I'm in the twilight zone here. Basically, Ms. Baldwin just argued a motion that's supposed to be in front of you in 2 weeks that we haven't even got a chance to respond to yet. This is characteristic of father in this case. He says, bad mother, bad mother, bad mother. But the reality is this isn't about mother. It's not even about father. It's about the child. And that's something that father seems to always forget. Father says, give me fees because visitation was suspended. Keep in mind, mother didn't ask that visitation be suspended. This was a GAL recommendation that neither party knew what the GAL was going to say. It's absolutely ridiculous to say this is all mother's fault when this is based on the investigation of a GAL, a neutral GAL that the court appointed because these allegations of alienation and things like that were going back and forth. And the court said, okay, bring the GAL in. And neither party knew what the GAL was going to say. All right. This was the recommendation of the GAL. The reality of the situation, if counsel wants to argue from their own material that our response is being filed as I speak, the visitations have been going horrible with father. That is the reality of the situation. There's no question that the child's behavior has escalated, and it escalated when the visitation started taking place in father's home. Yes, supervised visitation is going well. I would submit to the court that if it was still supervised visitation, it would still be going well. But we have gone through this again and again, what was going on at father's house. He attempted to alienate the child from not only mother, but the other family members, and it backfired on him grossly. This is a 13-year-old child, and father indicated that he was talking to this child about blowjobs and drugs. It's just absolutely ridiculous to say, oh, this is all mom. This is all mom. Mother did what the court said, asked for guidance and said, look, he's not going. I've used Charlotte. She can't get him to go. And the court said, drop him off and drive away. And that's exactly what mother did. And he has gone on all of those visitations. So I deny that mother denies that she was on the phone and all this weird stuff. The reality is that the child's having problems. The child won't speak to anyone about these, won't speak to a counselor. That's the problem with the counselor. The child just says, I'm powerless here. It doesn't matter. I can't do anything about this. So I just try to get through the time at father's as I can. According to father's own filings, again, visitation is going horribly. The child's not engaging. There's destructive behavior at father's house. This has nothing to do with mother. This has to do with the interactions between father and the child in father's care, and father believing that he was going to get full custody of the child if he could just have the child say all these bad things about mom, and it backfired on him. Mother immediately identified that there was a problem going on with the child. She went to get him to into counseling. They indicate maybe an adjustment disorder, but the child is shut down. I mean, mother is deferring to the recommendation of the GAL at this point because child is shut down about it. Mother didn't know if the child was actually even going to talk to the GAL, because even as close as mother and child are now, he is completely shut down. He just says, I can't, I'm powerless. As far as the phone, mother thinks it's ridiculous that this is before the court. Father is a parent, taking a phone away from a child is in the discretion of the parent. So she doesn't even know why there needs to be a court order. If there's something wrong with the phone, then father needs to be a parent and take the phone away. At this point, things are so bad in his household, really, that don't know what good it's going to do, but that's his prerogative. And she's certainly not going to interfere with that. So that's basically where we are. We're deferring to the GAL. The GAL was kind of didn't really want to say a lot. It appeared at the last hearing about what was disclosed by the child, other than that he's very angry. We know from the counseling records that he's refusing to engage and talk to anyone. He feels absolutely powerless, and mother is doing what she's supposed to do. She is getting him there. If that is what the court orders, that's what she'll do. It's just so ridiculous that we keep coming back to mother's so terrible. Mother's so terrible. Again, who cares about the parents? All mom cares about is this child, and this child is having a very bad reaction. That's one of the reasons for the GAL, and mother is deferring to her. Thank you, Your Honor.
Thank you, Ms. Jeffers. Ms. Corey, I am going to ask if there is any information or any response or anything that you want to provide at this point, and then I'll turn back to Ms. Baldwin.
Well, I've actually seen some positive things in this case recently. I believe that Jaden being in a smaller school is going to be quite helpful to him. And although Columbia Wellness declined to get him started in therapy, Ms. Vick has sought out a counselor that's out in Calflamet that she hopes to get him started with. I'm not clear whether that was at the school through one of the programs or whether that's a private counselor. I'm not clear on. Also, I just learned that these parents have spoken with each other. And when one of the most significant things that I learned from Jaden is his anger is stemming from his parents not being able to even talk to each other. And he is in the middle. He's had significant life changes in the past, 6 months to a year, including the move to Calflamet, including the difficulties with his father, the trouble he has been in school. And I think it's a lot for him. I've seen evidence of alienation on both sides. And the fact that the parents have spoken with each other, trying to maybe work things out together, that speaks volumes to me based on where they were when this case started. It was, I didn't expect them to ever speak. So I was actually kind of pleased to hear that. But that's all the information I have at this point. One of the attorneys mentioned that it is difficult to get information out of Jaden, and that is very, very true. And I've spoken with him since my reappointment twice, met with him twice, and really all that's coming through is his anger, and anger at both of his parents, really. And that we're still here after 2.5, 3 years, whatever it has been, that he is ready for it to be done.
Thank you, Ms. Corey. I appreciate it. Ms. Baldwin.
Thank you. I think that's just it. Kid's tired of being in litigation, and I don't blame him. I think sometimes we sit high and mighty over kids, and they get frustrated because despite Ms. Corey's involvement and counselors, at some point, kids are done. And this kid's made it pretty clear he's done with Rosen, he's done with counseling, just wants it to be set. But it also is pretty clear that mom doesn't, because these folks were cruising towards that quickly in December, and that was 100% derailed by mom and mom alone. And we know that from Charlotte Rosen, because Charlotte Rosen was moving forward. Everything was hunky-dory, no negative reports whatsoever reported from mom, from Charlotte, or my client back in December. And that was that same period of time where then mother just said, oh, I learned I don't have to do what you want, so I'll ratchet back. So it's mom who's put child in this position of just kind of ripping him back and forth and then saying, oh, I'll wait for the court to decide. I'll make the court to decide. And that's not appropriate as a parent. That's not putting your child first. That's not putting your child in a position to succeed. Again, when you look at the record, the child's voice to Ms. Pullard is specifically that record says he described how his dad coming into his life was not causing any of the issues. So that's not it. Mr. is my client, father is not the reason. Again, I have big concerns here where the report from Ms. Corey is, oh, and by the way, there's a new counselor getting on board. Once again, where's joint decision making? Where is the information being provided that we're doing this? It's not that my client is going to say no. My client would generally agree to counseling, but the idea that that the mother can just unilaterally do that despite the court's order for joint decision making does speak volumes into her opinion of sort of her control over, I can control and dictate. And that's really what she's done. And that's what we've seen over and over and over again. Counsel saying, oh, and Mr. talks to him about all these horrible things. Where is that in the record? Where is there any evidence of that is admissible evidence? There is not a shred. It's just kind of these random things that they'll throw out where there's just not a lick of evidence behind it. And all of what my client puts before the court is like, here's the record, here's the statement, here's what I can provide. And so father provides all of that and has for 3.5 years. This kid needs it to be done. My client needs it to be done. we need to just move on to the parenting plan your honor already ordered. That's reasonable. So again, I'm asking that the court comply with the order that you already set forth, which would put us at this point in time on regular Friday to Sunday visits. Second, the phone should stay with mom. Counsel saying, oh, make dad the bad guy. That's not fair. Because mom says there's no evidence she even called the child. You know what proves that? Phone records. You know what we've asked for? Phone records. So that's one of those things that can't have it both ways. And that's what they're trying to do. Mom should be required to keep the phone with her. And if there's somebody to blame, I guess mom can blame it on the court. But that's reasonable to prevent that type of alienation from continuing. And finally, the fees that we've asked for, they're not due to the GAL. They're not due to the father's time being suspended 2 weeks ago, despite no evidence of wrongdoing on his part. That's because when you look at the record, the pattern of obstruction is clear, including the most recent pattern of obstruction of not providing the counselor's name, even though that was a direct order from your honor, sort of a do it right now, and they still didn't do it. So it's those types of things over and over and over again that when you add them up is a pattern of obstruction. That's what the fees are for.
All right. Your Honor, I feel like I should get to address this. It's not like Ms. Baldwin is the moving party who should get more airtime here.
Okay, briefly.
Okay, so with regard to the counselor, the court was very clear that mother needed to get this kid to a counselor. That's what she did. Okay, so to now say that that was in bad faith is just not true.
I think it sounds like there's a whole new counselor, not Miss Pollard. Is that correct, Miss Corey? That there's a new counselor local in Wahkiakum?
Well, mother's looking for one.
I wasn't sure whether she said she had one or that that was her intention. I thought she said that she did have one out there in the local area.
Okay. So I can tell you that the child is set to meet with Miss Pollard on September 6th to see about counseling options. So that's what I know. As far as a resolution, mother actually called father to see if they could come to an agreement. So to say that, mother is trying to prevent that from happening just isn't true. I have that evidence that will be filed today for the court's review. With regard to the phone records, I do have them. Unfortunately, I have been in trial and arbitration and have not had the chance to review them. The discovery request right now is not just between child and mother, it's between every person in human history pretty much forever. So the ability to review all those, I haven't had time to do so. We'll address that in the motion to compel. And quite frankly, attorney fees, any obstruction acts that the court felt mother did, she was already punished for through attorney fees. Father's just trying to financially break her. He actually makes 3 times more than she does. And it's inappropriate because he didn't like the GAL recommendation. Thank you, Your Honor.
Some of the concerns that I have about this case, it's obviously pretty contentious. The child clearly is caught in the middle. I think there's some animosity, resentment, and this is all just kind of my outsider perspective. Clearly, dad left mom in the lurch at a time when he was needed and could have been a pivotal person in her and the child's life. And so there probably is some leftover from that. Dad has tried his best to fix that situation as much as you can, and is now trying to repair the relationship with the child and has worked hard to do that. And through reunification with Miss Rosen and jumped through most of the hoops that the court's required of him thus far. We did enter May 9th, I think, May 9th, 2023. There was a temporary parenting plan that was entered that mom was primary. This was before the move. But mom was primary and decision-making was all joint and essentially was set up to start. There was some summer visitation schedule in there, but beginning August 1st, so moving into the school year, father to have every first, third, fifth weekend from Friday at 5 to Sunday at 7. And then there was an agreed holiday schedule for essentially the summer holidays with Thanksgiving break and winter break and any 3 or 4 day weekends not listed as reserved. So that was entered. And then within a couple weeks, we had a motion to modify and basically start from scratch. And so we've not been, that plan never really had a opportunity to take flight, so to speak. I understand concerns that the parties have. I just am a little concerned because I don't, there's a lot of one-upsmanship here. Well, mom's the one who called dad to talk it out. Okay, I don't care. The fact that they talked is great. We should be encouraging that and not like putting brownie points on one side versus the other, to be very frank. The fact that they're willing to do this, and especially since Ms. Corey's input from the child is that he just wants his parents to be able to just coexist reasonably. That doesn't mean they have to be best friends. That doesn't mean they have to hang out. That means that he can have a peaceful existence in each of their homes and not have to worry about any of this. That's kind of what it sounds like to me, to be very frank. I'm glad to hear that being in a smaller community and maybe in a smaller school will benefit him. And so that part of, the decision for the moves pretty much was done, and we're where we're at. So I'm happy to hear that. What I'd like to, I reviewed sorry, I'm scrolling through Odyssey here. I reviewed the information that Ms. Jeffers filed yesterday. I got that this morning. I reviewed everything. And, I think it's appropriate for, assuming he's willing to engage, for the child to have access to a counselor. I guess my personal opinion is, forcing therapy on children doesn't necessarily do any good if they're not willing to engage. But I think having the access to somebody that he is comfortable with is extremely important, because you never know when the child's going to want to actually reach out and utilize that individual. So I think that's great. I do think mom and dad should discuss that together. I did see I think it's one of the last pages Ms. Jeffers submitted was that there's a intake appointment for the 6th of September at 9 a.m. for the child in this case. So whether she can remain or if that's someone that the child's willing to engage with, I guess is to be determined, but I think there needs to be a counselor available to the child. I think we're in a situation where, as much as I'm concerned, the parties should not be speaking disparaging of one another. They should not be discussing this case at all with one another, or with the child, excuse me. I misspoke, with the child. So no disparaging comments to the child of each other, no discussing the case or any other adult topics with the child. I want to reinstate the May 9th parenting plan. And as I stated, I do want the child to have an opportunity to have a counselor that they can reach out to. I understand the request for the phone, but I'm not going to, this kid's gone through a lot. I understand that the concerns with mom reaching out repeatedly to the child by phone. Let's have the phone go with the child. Mom only to contact the child if in an emergent situation. And if dad needs to limit contact or limit phone usage during his parenting time, then he needs to limit phone usage during his parenting time. And I'm not going to authorize any attorney's fees. So I know that the parenting plan from the 9th, as I scroll back to it, indicates that it is the first, third, and fifth weekend defined by the first Friday of the month. I don't know where that puts us. I would assume the attorneys could determine that for any exchanges upcoming. And it does appear that we're here next or in 2 weeks on the 12th for a motion to compel. Is what I show.
Yeah, so we're probably going to be back in 3 weeks on a motion for a protective order.
I'm glad you're so enthusiastically optimistic about this, Ms. Jeffers. I don't know. I'm concerned about attorney attitudes impacting the client's positions on this case as well, to be very frank. So if you and Ms. Baldwin don't get along or completely disagree about this case, I'm worried that that's impacting your clients. I'm concerned about that. So I don't know that we need to enter another order since that parenting plan was entered May 9th. If we want to, if we have any presentation of any orders, we can set that for the 12th, if that works for the parties.
That works, just because I think everything you order is already part of the May 9th, except the limit on mother can only contact child via the phone like essentially in an emergency. So I think that's really the only difference, but I think that still should be reduced to an order. Additionally, I just want to make it clear, we don't have any objection to Stephanie Bullard. The child's already met her once, that's fine. But if a new counselor is being chosen, then that needs to involve both parents. And so we just want to make that clear. It's not, again, my client's not against counseling. He's 100% on board and in favor of it. But he wants that to be a joint decision on who's being selected.
There is joint decision making on that, so that is appropriate. If it's Miss Pollard, then that's great. If she's available to continue being accessible to the child moving forward.
And I don't think that's the case, Your Honor. I think she's meeting with him to try to determine who a good counselor will be for him. It was her recommendation that he might do better with a male counselor.
Okay, well then, as long as that information is shared to all the parties, then any updates, any names that she suggests, anything like that, I think we just need to try to get these folks to see if they can work together without the assistance of counsel. That would be great. So we'll set this to any presentation to the 12th, and we'll see you back in 2 weeks.
All right, very good.
Thank you, Your Honor.
Your Honor,
Good
Michael
luck.
Reed appearing for Ms. DeDios.
Good afternoon.
And Heather Hoke, appearing for OBA for DeDios, the petitioner, Your Honor.
Good afternoon. I have reviewed everything that's been filed in this case, and Ms. Hoke, since you represent the petitioner, I'll take any argument from you first.
Okay, I guess I'll try to be fairly quick. The first thing, my client really wants the Lexus vehicle back. He traded in a separate property vehicle for that. She took it without agreement last January and has had it for 8 months. She indicates in her response that she'll make the payments and refinance it. She hasn't made one payment or attempted to. She hasn't paid the insurance on it. And according to her financial declaration, she has no income, so she can't do that. Some of the concerns that we have are she has a bachelor's degree in accounting and some kind of legal training. I don't know if that was paralegal or what, and she indicates she hasn't worked for several years, but my client has told me that she did work at Volt Temporary Services in Seattle during one of the times that she left him. So speaking of leaving him, they were married about 3 years ago, but she has been out of the house 22 months and in the house with him 20 months. So she was there for about a year and then she left, and then she was there again temporarily and then she left. That kind of impacts the immigration issue here because he did get an appointment after they got married, but she left again before they could go to the appointment and work on getting her green card. So to the best of my client's knowledge, she has an INS work visa. Possibly she did, and he thinks she might have renewed it. So in any case, you can't just sit for 8 months, not get a job or make any forward movement and then come to the court and say, I still want to keep this Lexus. And by the way, I want spousal support. I'm not going to tell you how much. You can decide that. But she has minimal costs. Someone's paying her rent and housing and all that. Her main cost in her declaration was the Lexus. The problem is she's not making the payments and she has no, as far as we can see, no way of doing that. So together with the fact that it's been about a 20-month marriage and her failure to even try to get back on her feet, as far as we know, we just feel that it's not a spousal maintenance case. He should be able to get his retirement vehicle back. The vehicle he traded in for it was his separate property prior. He owned the home prior to marrying her. And frankly, it's just been a debacle. She took $20,000 out in December of last year, and then she came back the next month and took the Lexus without his permission. So she's had a pretty she's had some funds to live on. She also has, at least according to what she's told my client, some property and other assets back at home. And she hasn't revealed those in her financial declaration, but she revealed them to my client. So we feel that she's just being disingenuous with the court. The last issue, I think, unless you have questions, is the attorney fees. They have filed one financial declaration, a 2-page declaration, and a notice of appearance, and she's indicating that her attorney fees are $7,422 so far. I can't imagine where that came from. We filed a petition, summons, motion for temporary orders, motion to allow publication, order to allow publication, amended petition, amended summons, financial declaration, sealed documents. My client's fees are $3,500. I've been in this case since January. So I don't know if that's just an effort to get some fees, and they didn't submit a fee statement, but I think that's pretty outrageous. I think Mr. Reed's appeared a couple of times to ask for continuances, but this is our first substantive hearing. So in short, my client would like the Lexus back. They each keep what they have. He's not going to make a claim for the 20,000 that she took. I don't know if there'd be any way to get that back. So I think he's just, he's trying to be efficient here. And then they each pay their own household expenses and the like. One of the things that's kind of hovering over this case is a DV situation. She did plead guilty, I believe, to an assault from hitting him with a jar of aloe vera that cut up his face. So anyway, this one's over. We just need to figure out how to finalize it, I think. Thank you.
Thank you, Ms. Hoke. Mr. Reed?
Your Honor, here's what happened. My client left the Philippines, moved to the United States to be with the petitioner. He left her. He continues to earn an income. She doesn't have an income. The only real item in question here is the Lexus. She clearly can't afford to pay the Lexus, but she does continue to need the support. The statute for, as far as spouse supports, indicates that what we're looking at is whether there's a need and whether there's an ability to pay. Mr. De Dios has an ability to pay for the Lexus, and she clearly has a need to continue receiving that. She's not asking for any additional support at this time. If there's an issue with the amount of fees that she's been charged, I'm not clear on how that is impacted by the motion in front of the court. What this really just comes down to, Your Honors, is my client has a need, and there is just this one property item that she would like to continue to have, that she understood was given to her as a gift, and she would like to continue to have it. And we hope that Your Honor will let her do that.
Can I respond, Your Honor?
Yes.
First of all, he did not leave her. She systematically cleaned out his house that he owns and left, and told him she was going on a mission. So there's no evidence or anything that he left her, which probably doesn't matter anyway, because it's a no-fault state. The other thing is her need is self-generated. She's been out of the house for 8 months. She has a bachelor's degree. She has the ability to work. She just has chosen not to do it. And the court generally frowns on people, holding back for months at a time from trying to get some kind of employment. We look at child support in the same way. You can't have self-generated lack of income. You need to make efforts. We saw nothing on any kind of effort of hers to get a job. It wasn't even mentioned in her declaration. So I, again, think that she's being disingenuous with the court, and it's not appropriate for him to provide this vehicle to her. She needs to start pulling herself up by her bootstraps. Also, the only issues you look at for maintenance are not just need and ability to pay. You look at the length of the marriage. Generally speaking, in case law, a marriage of at least 3 years or more might be looked at for a minimal amount of support, but these people have only actually cohabited for 20 months. So I just don't think it's a maintenance case, and that's our position. Thank you.
Thank you. I'm a little confused because there's some discrepancies between what Mr. Reed's indicating and what Ms. Didios has indicated in the one declaration that we received from her that's about a page long. So she is asking for spousal support in her declaration. She's also asking for the Lexus, and that he pay for it, and if he doesn't pay for it, that she'll pay for it. So my assumption, Mr. Reed, at this point, that he's paying for it one way or the other, either by spousal support or by continuing to pay for the Lexus. Is that her plan?
Well, that is what she would like to have happen, of course.
And what information do we have that this was a gift from him to her, other than
as noted in her declaration?
Okay. And does Mr. have any other vehicles that he
pick up? But she doesn't have a driver's license. So I don't know if she's been driving it or someone's been driving her. He's got a 25-year-old pickup that he's limping around in. But, he bought this for his retirement and with a separate property vehicle as the down payment. So it's really not appropriate for her to take it, keep it, and then be allowed to continue to use it.
And I can't say anything to whether she has a driver's license. That's not on the records anywhere.
She had the 20,000 that she took when she left. She could have purchased a vehicle with that. We just don't know much. As you indicated, we have a financial declaration, but no records. And we have a 1-page declaration from her. So it's pretty skimpy information to go forward and try to award or anything.
All right. Clearly, the petitioner in this case has provided a lot more information. I understand Mr. Reed's position and the difficulties he's having being able to communicate and get information from his client, and so I appreciate that. Here's what I'm going to do. I'm going to enter the temporary orders as proposed by the petitioner in this case. I'm going to ask, I'm not hearing any response about the $20,000. I have more information from financial information from the petitioner than I do the respondent in this case. And that's kind of been an ongoing indication that this sum of money was withdrawn. I'm not making necessarily a finding on that, but clearly that is a decent chunk of money based on her financial statements that she's provided that would afford her 18 months of living expenses, essentially, given what she's saying she's paying to live now. So it's a pretty significant chunk. I am going to order the Lexus be returned as per the proposed order from Ms. Hoke. The only thing I'm going to change on this is I am going to authorize a one-time contribution to attorney's fees from petitioner to respondent. I'm going to have that be on a 90 days before interest. And I'm going to authorize $2,000 in attorney's fees for the respondent.
Can we determine a date and time for the Lexus return, Your Honor?
Mr. Reed, is that something you can answer now, or I don't even know where she's residing?
And she would prefer that not be on the record. We'll have to work out an arrangement.
Well, what we can do presentation of orders in a week, and we can just say it needs to be exchanged by that presentation date of the 5th.
We have another week on that, Your Honor.
Your Honor, I'm going to draft the order. I don't know why I can get it to him by Thursday.
Oh, it's not the order. It's just to make sure that she's okay being able to provide the vehicle.
Well, you've ordered it by then, so I think we need to
I can give her until the week. I have also presentations on Friday mornings at 8:45, so we could do a presentation on the 8th.
That's fine.
To ensure the vehicle is returned by Friday the 8th at presentation.
Okay.
Does that work for the parties?
Thank you, Your Honor.
All right, so we'll set on the presentation of that order and review of the return of the vehicle for September 8th. That's Friday at 8:45. And that's a Zoom link that'll be on the Superior Court webpage, and it says it'll say Judge
as well
Fassett's
as Ms.
presentation
Gilmore,
is
who
Docket or
represents
something like that.
the mother of this matter. I represent the father, Cameron Gibson. We're on regarding the guardian ad litem report, as well as reviewing the restraining order in this case. Guardian ad litem did submit a report. It is the earlier.
Mr. Gibson is joining, as is Miss Gravina. So looks like Miss Gravina just came in. Mr. Gibson, it still just says joining. He's been in the waiting room joining for a little bit of time. So I don't know.
I'll have my staff reach out to him and just have him watch via YouTube. So I'm glad we were able to get the GAL back. She was here earlier. We did receive the GAL report. The report is compliant with the court's requests. I'll note, I think this was either the 3rd or 4th report Ms. Gravina has written on this case. And so the court was kind of giving her parameters of what it was looking for in that report. And I think that report answers the questions the court had when they assigned her this latest report.
Okay, I don't mean to interject. You received a report?
She emailed it to us as well as the bench. Let me hold on. It was earlier today.
I have it coming in at 12:32 p.m.
She emailed it to your group, Megan, to Megan's group.
I didn't receive anything, so I don't know if there's a typo there, but no, I've not received anything.
Hold on, give me a moment and I'll see if I can forward that to you real quick.
Can you hear me? It looks like I was able to get back in.
Yes, we can.
This is Tanea, the GIL. Thank you. I was kicked off and attempted to log back on, but was in the lobby for a bit.
Yes, we can hear you. And then Ms. Gilmore, I just forwarded that email on to you. So hopefully you'll receive that momentarily. And I recognize both parties are just receiving this so that clients have not had a lot of time to review and digest it. But in my quick review of it, it's looking at what the court had asked the guardian ad litem to do in this most recent report set and sort of the questions that the court had, kind of given the evidence that we were looking at in November, December of last year, and then waiting for the subpoenaed information, getting that, and then sort of having some of the most recent issues this summer unfold. The guardian ad litem's kind of, to her credit, been kind of pushed out several times because the court's like, oh, but now I need a little bit more information, or we were waiting for things to come in. So in looking at,
Sorry, let me just voice my objection. So at this point, I have to voice an objection. I asked the court not to consider the report at this point. I literally haven't received it in my email yet. I'll close out my outbox and do it again, but I haven't received anything, so I haven't even been able to skim over it or forward it to my clients.
well, and I know that both clients didn't receive it that long ago. I think your Honor's calendar's full for next week. So, I mean, it's your option, Ms. Gilmore. Do you want to push out a week?
I think I have Mariah in the courtroom. I think the 5th is the 5th available?
I believe so. Let me check the numbers.
And I'm very apprehensive about setting it over. But again, this is on an immediate restraining order that was filed at the beginning of June. My client has had visitation in the meantime, and receiving a GAL report at 12:30 when she hasn't had any contact with my client since we were last before the court. So I don't have it for me. I haven't reviewed it with my client. We would like to proceed. We would ask the court not to consider the report, frankly, at this point.
I don't think you can have it both ways. With respect to Ms. Gilmore, I think because the court has to make a decision in the best interest of the child, the guardian ad litem report is important for that purpose. And we knew that we were skirting sort of the edges of timeframes on when the child's sexual assault counselor was going to be able to provide information to the GAL and when the GAL was going to be able to get a report out. So we knew that those timelines that we had set were razor thin. And so that's kind of where we are. So I'm fine to go forward, but if we go forward, the court should consider the report. If we're going to set out, that's fine. Give Ms. Gilmore time to look at the report. That's fine too. But I think it's kind of all, you've got to have it both ways.
So it looks like we were here on the 8th the last time. We were here on the 1st and the 8th of this month. We did speak with Ms. Gravina at that point. She indicated she would have a report filed before the 29th. She filed it on the 29th. I don't know if there was a misspelling in the email. And frankly, I glanced at it just to ensure that it went to everyone and assumed. I didn't look at, if there was a discrepancy in the email address that it was sent to. It is only 3 pages long. Have you received it yet, Ms. Gilmore?
I literally just received it.
Okay. It's only, I think, 3 pages long, and it is almost entirely about counselor information. There's a little bit of supplemental. I guess I'm going to pause. I'm going to give Ms. Gilmore a few minutes just to read through it. And then if you want to have a breakout room with your client, I'm happy to do that. And then there is room next Tuesday on the 5th. So if we set it over, we'd only have to do it for 1 week.
If you can break me out with my client, I mainly just need to talk to her about what she wants to do.
Sure. Let me do that here.
Okay. Thank you for doing that. We're just going to proceed today. We would like it to be addressed.
Okay. Very well. And Ms. Gilmore, you had an opportunity to look through the 3 pages.
Very quickly. I don't have a meet, but I got the recommendation.
All right, very good. So again, guardian ad litem has sort of been tasked with like multiple reports at various points in this case, has complied with doing all of those, despite some of the hiccups in getting information and having to subpoena information for her that was pretty critical into understanding the realities of what was going on. So when we look at the context of the guardian ad litem report and the restraining order that currently exists, the primary concern is the child. And sort of the buck stops there, is that this isn't about what Mrs. wants and not her desires. And it really isn't about what my client wants either. It's really about what this child needs at this time. And so the goal is to make sure that we're meeting that child where they're at and not forcing things child's not quite ready for or putting the cart before the horse. When we have to look at what we know as a verity. And so there, in many cases, there's some he said, she said, but in this case, there's a lot of verities that we know that we can rely on and evidence that really isn't disputed. So we know that Mr. Rosales is a dangerous person. We know that he has a criminal assaultive history, a domestic violence assault convictions. And I believe those were regarding strangulation and domestic violence. That's extremely concerning. We know he's a felon. We know that there are findings against him in his prior parenting plans that restrict him from any contact with his own children. And this is why the court previously prohibited all contact with him between him and the children. We also know that for approximately a year after that order was entered prohibiting all contact, that the respondent allowed Mr. Rosales contact with the children in violation of that court order. And while she did that, she was dishonest with the court, with the guardian ad litem, and with my client. And the concern here is that, well, this is not direct evidence. The circumstantial evidence that's extremely strong is that the children were either taught to or forced to lie about Mr. Rosal's contact them. These are fairly young children. One's just starting kindergarten this year, and the other one is 3 or 4. So these are young children who naturally are just going to kind of spout stuff out, absent some parent really putting a cap on that and prevention on that. And so there's strong circumstantial evidence that that occurred for more than a year, because this wasn't something my client knew was happening. In October, November of 2022, this was found out. There was direct evidence that Mr. Rosales has having direct contact with the children. And the court at that time then moved the children to my client's home and restricted the mother's visits. But even then, the mother continued contact with Mr. Rosales, despite the court's order that at that point was more than a year old, that he wasn't to be involved in the children's lives and was essentially a bad idea. She continued, and despite the fact children were being moved out of her home because of him, she continued that relationship with him. And what's concerning is, even as we stand here today, her declaration says, I stopped all contact with him in January of 2023. And that's from page 3 of her declaration. This is December or January of this sort of last 6 months ago. But then when you look at, if you were to peel back your file and look at the phone records that were all filed, we see phone contacts with them that continue through March of 2023. So again, there's concerns here that sort of mom's just going to say what she's going to say match up with the evidence at hand. And I'll note for the court that our phone records stop in March because that's when our subpoena was responded to. So we don't have anything past that, but that's the concern. So that even then, so children are moved to my client's home. The oldest child's put into therapy. The younger child is frankly just too young. There really aren't therapists for, at that point, a 2-3-year-old. We then fast forward a couple months, the oldest child starts making disclosures. Child ends up with a special trauma sexual assault counselor that's working with that child. We do have the letter from that specialized counselor. That counselor indicates there's, between the counselor's letter and the guardian ad litem report, no indication of coaching from father. This is not something that father wants whatsoever. This was heartbreaking for him to have this information that verifies at a minimum that Mr. Rosales had direct, very inappropriate contact with this child. Whether or not that contact rises to the level of sexual assault still is a question that remains to be seen, but still that this child was exposed to somebody and was intimately cared for by somebody who had frankly no business being around that child whatsoever. And the concern here is that this is coming out because the children finally feel safe to make these disclosures and finally have been in a situation in a home long enough where the repetition of we don't keep secrets, that's not something that we do, that's finally rang true for them. And they finally had sort of been untrained from secret keeping to telling what's happening. That takes time. So at this point, the biggest concern is the specialist says that the child needs additional time, essentially 6 to 8 more weeks of specialized counseling is appropriate for the counselor. This is pretty critical time for this young child's processing. Child's only 5 years old, again, kindergarten age. The child, again, is in the position where they're unlearning that secret keeping and being put in a position where they are clearly told, and it's repeated through repetition, that not keeping secrets, you won't get in trouble for that. And that bad things aren't going to happen to you or anybody else when you don't keep those secrets.
I just like to voice my objection. This is hearsay with no personal knowledge. There is no direct evidence that my client has ever verbalized these words to these children. So we're just making the blatant allegation without any substantiating evidence at this point. So I object for hearsay.
So I was very clear that there's circumstantial evidence that mother has required this due to the children's behavior and what's happened. And additionally, when you look at the counseling records indicate this is what the counselor is doing. And so that's what I'm talking about right now, is what the counselor is doing, which is part of the GAL report and part of the counselor's letter. Oh, you're muted.
I'll note the objection. I understand Ms. Gilmore's concerns. I think understand what Ms. Baldwin's trying to argue, and it'll all be weighted.
Okay. Again, child's in that process with the current counselor of sort of unlearning some of those old behaviors. And again, being in a place where, as she finally provides information, there are not negative consequences attached to it. And that's something that I think children have to learn as a practical aspect. It's one thing for adults to say it, and it's another thing for a child to see it in action and say, well, if I disclose this, is the world, is the sky going to fall down? If I disclose this, is everything bad going to happen? And when the child sees that bad things aren't happening and that it's okay to tell the truth and it's okay to not keep secrets, then that child can be reassured that further truths can be told and the child can be free to just say what happened in their time. But that's kind of the key, is it takes time. Again, my client's only goal is the child's best interest. My client fully recognizes that at some point there'll be some sort of reunification with mom at some point. The question really is, when is the appropriate time to do that, and then move back into the supervised visits that were happening prior to this summer. The current recommendation is that child's further counseling will go through October 20th. So we're looking at about 6-8 weeks from today with that specialist. The child does have an underlying counselor as well, but this is sort of that specialist counseling that's really focusing on the sexual assault. What we'd like to see happen is the child to have the space to be in that counseling without mom's interference through that October 20th. After that, I don't want the parties to have to come back and then relitigate what do we do now. At that point, we think doing some reunification counseling would be appropriate. The reunification counselor should be located where the child is located. While Zoom is nice, I just don't think that works for young children. And these are young children. I don't think sort of zooming in is effective for young children. So the reunification counselor should be located where the children are. I think the reunification counselor should indicate how long that reunification needs to last. It might need to last a couple sessions and we're done. It might need to last a while, but I think that should be to a large degree dictated by the reunification counselor. I think these are younger children. My hope is that it's relatively short, and that at that point we would return to the prior parenting plan, with the exception of, so mom was receiving a couple hours supervised every other week. At that point, I think it should return to professionally supervised visits for a period of time, and then after those, and then remain at that level, frankly, until we get to trial. This is a case where trial is appropriate, discovery is pretty much done. It's time to move on and time to have the case resolved one way or the other. And so that sort of gives us a pathway into what's appropriate. And again, it's focused on the child and what the child's needs are right now, but also is progressive and moving forward. So again, my client does not want to eliminate mom. That has never been his goal, never his desire. He really is just, I got to put kids first and what they need first over sort of everyone else's desires. Finally, the guardian ad litem in this matter has recommended a psychological evaluation with a parental risk component. We think that should be ordered. And we have a long track record of behaviors that are, frankly, somewhat irrational. We have Mrs. just blatantly lying, and that's pretty rare. To some degree, like everybody twists the truth in their favor, but I would say it's pretty rare when somebody says, the car was black and the other person says the car was white, and here's the picture of the white car, and then the other person still says, the car was black. I mean, that is the level of odd dishonesty that we have from the respondent that really doesn't make sense. I mean, we see it even now with her statements of sort of when she ended the relationship and what she told the guardian ad litem and what the records show. None of those line up with the respondent's story. And we have her doing all this counseling and sort of, she can say all the right things and do all the, so I should say all the right things, take the right classes, check the boxes, but then immediately is in the same behavior as before. And so that's the concern, is we really have somebody who has not applied any of those lessons. She can tell you she'll tell you all the right things, but there's no indications that she can be a protective factor for the children. And that's really the key here, is that how do we allow time with the parent when that parent can't be trusted to protect the children, and will not put their needs first, and not in a, it's not even saying kind of in a selfish way, but in a way that is, in a way that borders on criminal neglect. I mean, it's that level. And so that's sort of the underlying concern that makes the psychological evaluation reasonable and valuable, because it can provide everyone with information on how we craft a path forward. And I think that's somewhat what we struggle with, is what does the ultimate path look like in this case? And I think that will give us information. Mother says, I don't have any money for that. Good news, the house sold. And so in this case, we are going to have money to do that. And so what the court should do is authorize funds from the home sale, which should be completed in September, to be utilized for that purpose. So mother can get in line right now, and there's money to pay for it. And then if she's in line right now, frankly, given the court schedule, by the time we get to trial, we'll have it in hand. And so that's a reasonable solution that gets us, frankly, that plan kind of gets us through to trial. So it's reasonable, it's in the child's best interest. And so we'd ask the court to adopt it.
Thank you. Ms. Gilmore.
For the record, Megan Gilmore on behalf of the respondent and non-moving party, namely Jill Gibson. The history of this case is particularly important. I know that Your Honor wasn't before the court at the temporary orders hearing, and I think it's extremely pertinent when relating to and making the decision between the contact of my client and the children. Particularly, my client was a stay-at-home mother for the first 4 years of these children's life, while father works 12-hour shifts 5 to 6 days a week. My client's role as the primary parent of these children was acknowledged within the temporary parenting plan that was entered in November of 2021. The parties lived under that parenting plan for another roughly 12 to 13 months. During that period, father brought his first motion for immediate restraining order, which was ultimately denied in March of 2022. He then filed a subsequent motion in the fall of 2022, which ultimately resulted in the transfer of custody. I think the timeline of this case is particularly important because I think that there's some allegation that this order prohibiting contact between Mr. Rosales and the children was in place before it was. It's my understanding that the order was entered in response to the denial of the restraining order, which again was entered in March, April of 22. So the restraining order of the contact was only commenced around that time. Again, as acknowledged within the February 2023 GL report, my client, following the temporary orders hearing and transfer of custody, has done over 11 hours of classes, and again, appreciated the severity of her actions. She's repeatedly acknowledged remorse for this isolated one-time incident of violation. She explained to the court in past declarations that it was associated with some sort of something to do with the house, but frankly, it really doesn't matter. There was one violation, and there's subsequently zero evidence that there was repeat violations for over a year period. The order was again entered in March. There was an alleged violation in October. My client acknowledged that a violation, subsequently sought treatment, has acknowledged it, and is doing what she needs to do to, again, for the best interest of her children. The court did enter a temporary parenting plan in December of 22 that provides my client supervised visitation. The approved supervisors, Aaron Hall and Jennifer Harrington, filed declarations on June 23rd. The supervisors attest to the strong relationship these children have with their mother and frankly, the success of visitation. The supervisors are only people with personal knowledge. So there's lots of, again, allegations as set forth within my objection that my client's doing and manipulating and speaking poorly of and hiding in secrets, but there's zero substantiating evidence in the record or personal knowledge of anyone that this has actually occurred. The child has allegedly disclosed things during father's visitation, but that doesn't mean that my client was hiding anything in the interim. The GAL filed her most recent report prior to this one that I just received about 5 minutes ago on February 7th that indicated that my client presented no risk of harm to these children and frankly recommended a 50-50 parenting plan. We're looking at what I was like 4 or 5 months ago at this point. It's also important to highlight that within that recent GAL recommendation, father indicates that his only concern relating to mother's visitation is relating to Mr. Rosales. My client testifies under penalty of perjury that she's had zero contact with him whatsoever since January of 2023. There is zero evidence confirming that she has had contact. If there's any sort of communication or evidence within the records, which I frankly didn't see, Mr. Rosales would be potentially contacting my client, but you don't see any responsive materials back, then my client has in fact been in communication. I think it's also important to note that the order prohibits the children from having contact with Mr. Rosales. The children frankly haven't had contact with Mr. Rosales since we were before the court in fall of 22. My client's visitation has been supervised. So I think there's a big confusion between having contact and violating the parenting plan, which again was one isolated incident in October with alleged video, and claiming that my client has then continued to expose the children over that 6-month, 12-month period. There's been no contact between Mr. Rosales and the children as my client has been having supervised visitation since December of 22. Conveniently, after receiving a GAL report in February that was not in father's favor, father filed the motion for immediate restraining order, alleging that the child disclosed at the end of May that Mr. Rosales had inappropriately touched her. Father motion requested that my client's visitation was suspended until a CJAC interview was completed. As filed by my client as a pro se litigant in June, and again on August 30th, the child made no disclosures to law enforcement during the CJAC interviews and the investigation was closed. At the June hearing, father alleged that the child made another disclosure in support of his request for continuance. The immediate restraining order was improperly set over by the commissioner for another almost 2 months to today's date. Since this hearing, the allegations of disclosures have been investigated. There's been no disclosure to law enforcement. And again, the investigation has been complete. But frankly, I believe that procedurally, again, Washington State is a notice pleading state. I think procedurally, father's motion is moot. The CJAC interview has been completed. There's no disclosures made. My client should reestablish visitation just based civil procedure alone. At this point, I'm having a very hard time connecting a nexus between the alleged abuse of Mr. Rosales with denying my client visitation. There's simply no evidence that my client has had any contact with Mr. Rosales whatsoever for almost 9 months at this point. There's zero extrinsic evidence whatsoever outside of father's self-serving statements that my client has ever manipulated the children or forced them to lie. What you see is declarations from people with personal knowledge that were agreed supervisors that this visitation was going great. You don't even have an allegation visitation was going poorly prior to father throwing a bomb in the water and making the ultimate allegation that's almost impossible to prove that a very minor child was hurt or injured by a significant other. As set forth within the correspondence of Richard Dillman, my client has been seeking regular mental health counseling since 2021. We filed that under seal on June 23rd. And so again, we just don't see a connection between a safety risk of my client having visitation to the children. My client was having successful visitation for 6 months. And I seriously have very serious concerns the father is involving these children in conflict, as we have a just recently turned 5-year-old child alleging that and declaring to this provider that her mother is a liar. My client testifies to that she's been a primary parent of these kids for a long time. And this is a very small child. They can't make those sort of declarations, determinations that my mom is a liar. Fathers intentionally put my client in a situation where my client has no visitation for 3 months, while intentionally creating a new status quo, while also creating roots in a community that the children frankly have never lived in. We kind of skip over the fact that father, number one, violated the parenting plan and joint decision-making by engaging the children in services. Again, not saying that my client would refuse to do that, but no discussion, no information about the provider until I got in the case. And then the fact that he's now enrolled the child in school up north when the child has lived in Cowlitz County her entire life, and we're under a joint decision-making parenting plan. I understand that there's an immediate restraining order, but that doesn't change the temporary order relating to joint decision-making. Moreover, the counselor is recommending that the child have in-person visits because this has all been happening over Zoom. So again, as Ms. Baldwin has indicated, Zoom visits don't work very well. So not only do we have that, but then the counselor has their own concerns about manipulation of father. So these visits need to happen in person. And I do suspect that if this child is having in-person counseling with this provider, that she likely wouldn't have any disclosures, just like she didn't have any disclosures to the CJAP. That being said, my client prays that this child wasn't injured in any way or inappropriately touched, and she would be the first to step in and draw the line and say, you know, this needs to be dealt with and to protect her children. The children are ultimately the only one that have been injured by this motion for immediate restraining order. They've had no contact with their primary care provider, who has been their primary care for their entire life until the last 8 months. And my client, again, is willing to do whatever necessary to, you know, be in compliance with the court's order, to have visitation with her children, and to regain at least a reasonable resolution and a reasonable schedule for these children that are in their best interest. We do think that there's been zero substantial change of circumstances since the recommendation was made by the guardian ad litem in February. And we think that we need to move forward. I asked the court to deny the restraining order. I asked the court to adopt the GAL recommendation that was filed in February. My client is willing to do a psychological evaluation. However, and I don't doubt the court would dispute this, but the Dr. Poppelson's office is not doing one for six to 9 months. So that's really a non-starter when we're talking about visitation, or balancing my client's constitutional right to parent her kids, ultimately with the best interest of the children in mind. My client's not a danger to her kids. She's not telling them to lie. There's no evidence of it. So we ask the court to deny the restraining order.
Thank you. Ms. Baldwin, briefly.
We do have Ms. Gravina. Do you want to speak with her first?
Sure. Ms. Gravina, any additional information or comments you want to make at this point?
Not significantly more than what I already put in the report, just simply that I didn't get any written reports or notes or updates from the counselor after the child's last appointment. I filed anyways. I did call both attorneys after my telephone interview with the provider and let them know the information as far as the provider shared it, and then put that same information in the report. But outside of that, there's largely no other information available at this time.
Right. Thank you. All right, Ms. Baldwin.
Thank you. I appreciate that Ms. Gilmore has not been in the case as long as I have. And so sometimes I think that leads to an incorrect impression of what's happened and what's gone on. I'll note that early in the case, my client indicated he was a highly involved parent, that he would at that time argued he was the primary parent of these children, and the one that really was the parent who would step up and take care of their best interests. He's the parent that's fought to get them vaccinated, got them into counseling. All of those things have happened because of my client. Yes, my client enrolled him in school. This is a compulsory attendance state, so it's odd that that's an argument. The services and counseling that the children were enrolled in was something that was indicated early on in the hearings where the court changed custody. Everyone was made aware of that. That was something that was just frankly, I think, on the record, because we said we knew that was going to be hard on the kids. And so my client was like, that's something that's just going to happen, of course, happen, and there's no objections. Odd again that mom sort of tries to spin that at this point in time. When we look at, mother says, oh, I did 11 hours of classes. That is not sufficient. The idea that you were dishonest with the court for a year, and we know she was because we have all of the phone records and clear indications from the guardian ad litem. So we have evidence to that fact. Well, I'll just take 11 hours and sort of I'm cured. That is not logical. It doesn't equate to, it doesn't match with what's happening now. As far as, oh, mom's better, we really don't see that. This is a 5-year-old child that's made these disclosures. A kid calling somebody a liar is frankly exactly what a 5-year-old would say. 5-year-old's not saying, oh, so-and-so is dishonest. That a liar is a little kid word. And so it's a child sort of recognizing that for herself and feeling that frustration of one thing was said to me and now I know that that thing isn't true. So those are very much in line with children's speech. When we look at the violations here, we've had contempts of mom withholding the children, playing games with trying to prevent dad from being able to pick up the children from their daycare. There's a long history of mom's intransigence in this case. And again, I don't want to go into all of the history, but she's already been held in contempt once or twice with other things that came really close. So again, long history of mom sort of being a problem. In this case, I'm sure these children, they love both parents. That is not the question here. The question is the best interest of the children and how we facilitate ensuring their protection. And that is the biggest concern here. When you look at the phone records are attached to Exhibit L of my client's declaration. I think that was filed back in May. Those phone records are probably half a ream of paper, and it is very, very small type. So we're talking like 0.8 type and just page after page after page of the contact. And the sole contacts are him and her. So that's what the subpoena was, is this phone number to that phone number. And it's page after page after page of their contact. And that's just one source. So that doesn't count social media. That doesn't count other messaging forums. That's solely the cell phone records. So again, this mom tries to act like there isn't evidence. There is a lot of evidence to the contrary, that just absolutely black and white disputes mom's statements. Child has made disclosures to the counselor. Counselor put those in the materials that we filed. The records show intimate contact between Mr. Rosales and the child, and so that is the inherent concern. That occurred on mother's time. Mother allowed that to happen, and child's clearly extremely upset about it. And either one of two things are the outcome. Either one, child could not tell mother, or two, child told mother, and mother said keep it a secret. There really aren't any other options. And so one is either child doesn't trust mother to keep them safe. And the second is that mother is intentionally interfering with the child's safety. But both things are bad. Both things put the child at risk. And that's really where we stand right now. Child needs, and again, this is not a forever situation. Child needs the space to process with the counselor, who is the professional recommendation that came from CJAC. And my client has sort of put forward a path for your honor. It's reasonable, it moves forward, and it moves forward sort of at the child's pace, because ultimately the child is the primary concern. Ultimately, we'll obey, of course, any order your honor makes, but the primary driving concern is and always will be for my client, the child's best interest.
All right. Thank you very much. I know this is a difficult situation. This is, there's been a lot involved in this case. There's, frankly, I think by the time this gets to trial, it feels like a lot of the issues will be resolved just because of the piecemealing of this case as we've pushed through. I am, as I stated previously, I'm very glad Ms. Gibson is represented now. I think that's to her benefit, and I've reviewed everything. I feel relatively comfortable with the history of this case, and I do have some concerns. Mom says it's, a one-time issue, but it wasn't a one-time issue. It was kind of a repeated issue with this individual. And to be very frank, there was concerns that the court had, and that's why the rulings that previously made were made, that hiding this relationship ongoing, regardless of what level the relationship was concerning and potentially putting the children at risk, given some of the information. Okay, now we're here. We have these temporary orders. I see, and October 20th, I believe, is the date. I'm just double checking approximately that the counseling that was provided through the CJAC that was then extended by the counselor, and I believe that was Patricia Anderson, which is weird to say, but Patricia Anderson was the individual that's currently seeing the child and has treatment or counseling sessions set up with the child for the next month and a half, approximately. My understanding is that Patricia Anderson is in and around associated with Charlotte Rosen's office, Olivia Lovely. I don't know if, and so I'm throwing this out here because I'm kind of wondering if we can start things at this, if we can try to get things started. We had a brown bag, family law brown bag a week or two ago. Charlotte Rosen, Olivia Lovely, and Patricia Anderson were there representing their practice and what they're willing to do, and specifically to discuss reunification counseling. So I'm not suggesting that Miss Anderson do that, because obviously Miss Anderson is a reputation, or has a rapport now with the child. But my hope would be is, since there's some knowledge within that group of the circumstances surrounding this case, that either maybe and what they're asking the court to order is a reunification evaluation, which would be an opportunity for, in this case, it would probably be Miss Lovely or Miss Rosen, to have a quick interview with the parties at issue to determine how they can move forward. If that can happen while this other treatment is finishing up, then we can maybe be in a place where reunification counseling can start in conjunction with that other stuff finishing. Does that make sense? And I don't, and so their specific request was to say, we need a reunification evaluation, and then they're able to assess, okay, here's timeframes, here's yes, we can help, here's no, we can't. That is, they're doing that free of charge. So that's something they're just offering. And then obviously, as you move into whatever they offer, and since we have one of the children that's currently kind of in the same office, maybe there can be some working together. We do have to look at the best interest of the children. We also have to recognize that mom is mom. Mom's trying to repair these issues, fix these issues. I will order the psychological evaluation with parental risk component. Sounds like she's willing to do that. I understand that if it's out, let's get it started and get on the books for it. If we can.
That reminds me, Your Honor, if you could, my client spoke with Dr. Poppleton's office, and they're currently not even putting people on the wait list unless you have an order. So if you could potentially make a bench order to that effect, then I can get that started ASAP.
Yes, I can, let me see.
Ms. Gilmore, you could, if you want to like whip out a single line order.
I can do that tomorrow morning too. Yeah. Okay.
If you agree to it and you email it to me, I'll print it out and sign it and file it.
Okay.
Because I want to get, I don't want, I think the longer we wait, it is a detriment really to everyone, because it's sort of, each party is kind of digging their own trench and wanting to stay there. And we have to realize that if things progress in a positive manner, that mom is going to have visitation, mom is going to have a relationship with these children, and mom will need to be trusted to be a care provider to these children moving forward. So that doesn't definitively answer the question of what's the temporary order look like, but what I don't necessarily want to, I don't have anything from anyone, including in the GAL report, that says mom can't have any visitation until after this is done. If that's the case, then I'd like to know it, but I don't see that in anything that I've been provided. So if we can start this other process, and maybe it takes a month and a half, and mom's, because I do think that the proposed sort of tiered, we start with reunification, then we go to the supervised visitation with the folks that have already been approved, and we just kind of progress from there, because we need to ease the kids back into the situation, regardless of how or why these kids feel. At least the youngest feels some concern or animosity towards mom based on the circumstances. Why that is, maybe we'll eventually find out. If we don't, we don't, but we need to kind of ease them back into it. So I like the progressive nature of this, but I'd like to see if we can start reunification kind of in conjunction with the finishing of the therapy that the youngest is currently in.
But in the meantime, we can do that, you said, reunification evaluation as soon as possible.
Yeah, and if they come back and say, well, let's let's wait for 2 more sessions. I mean, I want to defer to them, but what I don't want is to say, okay, well, we'll wait and we'll set a review for, October something, and Ms. Gibson's just put on the back burner until then. So I'd let, if we can kind of start doing this all at once, that would be my preference. If Ms. Anderson comes back and says, absolutely not, this is not going to be beneficial, I'm willing to reconsider, but I don't have that information. There's nothing that says we need to put mom completely on the back burner until this is done. So we don't have I know that doesn't give you, I'll enter that order, the psychosexual evaluation, that order. I'll also enter a quick order for the reunification evaluation, if you want to put those both on in one. The only concern I have is it doesn't necessarily solve I don't know how to best word things moving forward. And I don't know that we have, besides next week, a review date that we can set before September 26th.
I
We
think
can
that
do a presentation on a Friday and have, if there's any additional information or concerns, but.
my thought would be, let Ms. Gilmore and I, so with that framework, I think Ms. Gilmore and I can craft something and then work with the folks doing the evaluation, the reunification evaluation. Ideally, once we see their scheduling, and then can get that evaluation back. My thought is the court's goal is not to delay, but also to move cautiously. So I think I can work with Ms. Gilmore on how to word that, sort of with the framework that you've given us. And if not, we can note it back up.
Yeah, that's my thought is maybe, we can enter an order. I will work to get the reunification evaluation completed immediately if we can, depending on Miss Lovely or whoever is doing its calendar. I would just ask that potentially if we do have a recommendation that's beneficial to my client that's saying, let's move forward sooner than later, that I'm allowed to put it on before the court with limited notice without a motion, just on a review.
My understanding is the court's orders, if they say reunification should proceed, that we proceed. So I don't think, I think that's what the court orders is. So I don't think we need to note it up for that.
Okay, if we're complying with whatever the recommendation is of evaluation, I think that resolves it.
Right.
Yeah, I want it to be safely done, but I would prefer that it not be delayed any further than the counselors believe is necessary.
Right.
Okay.
Okay.
I think we can work on a form. Oh, go ahead.
No, you go ahead.
So I think Ms. Gilmore and I can work on a form of the order. If for some reason we disagree, then we could just note it up on a Friday and hash it out. But I don't think we need to set a presentation. If Ms. Gilmore, if you'll draft that single line for the psychological evaluation with parental risk, I assume you're in agreement with taking those funds out of the home proceeds to get her done. And then I'll do one with the rest and I'll ship it to you. And if that works for you, and if not, we can chat.
Sounds good. That works.
Okay. All right. Well, I appreciate your time. Thank you. Good luck. I hope that plan comes together. We'll see.
Very good.
All right.
Thank you.
Thank you. And I believe we can go off the record in the courtroom.